Hello and welcome to another video, Squirrel Friends of the World. I'm happy to be here with you guys with the latest out of Idaho with the state of Idaho versus Bryan Kohberger. So, part of my everyday life as a squirrel, general squirrelin as it were, squirreltivities and the like, is refreshing the Idaho Cases of Interest website a handful of times a day, just to see if there's anything else happening, not just for Bryan Kohberger, but also for Chad Daybell, post-conviction and post-sentencing, and also his wife, Lori, as her case is going through the appellate process in Idaho. And sure enough, we have some new documents here filed on July 22nd, 2024. But before we get into those, I do have a handful of PSAs, as in public squirrel announcements. So the first of which, speaking of Squirrels of the World, I'm very proud to say that my vision is becoming a reality with the Squirrels of the World project, where we are able to map the different squirrels of the world with squirrel icons. Actually, it's the squanguen as a pin on the map for those who want to participate. It's completely voluntary. And we are going to be at some point doing a live stream where we kind of look at the map and all the different squirrels. And anyway, it's just something that we're going to do for fun. So there's that. Additionally, we are still finishing our coverage, revisiting key moments from the Det v. Heard trial, live trial plus sidebars. So be on the lookout for that if you're interested. But I'm really excited for the next project, which is going to be this mystery trial. And this trial somehow has kind of flown under the radar, I think maybe partially because there's only a few witnesses that are even on YouTube. Therefore, not only has, that to my knowledge, has nobody covered this trial gavel to gavel with any type of commentary or analysis, it's not even been available to watch on YouTube. What we're going to do is, again, I'm trying to keep it a surprise just to make it fun, right? Because again, since it hasn't been available on YouTube, I would be very surprised if anybody has seen this entire trial, including myself. I had only seen the videos that were available on YouTube prior to starting this coverage. So I think we're all going to be able to kind of go into it with like an open mind, but it is a really interesting trial that I've been wanting to cover for a long time. And so the plan is that after the first live stream premieres, and I will update the title and everything. Right now it's going to say mystery, right? But of course, after that first live stream, everything will be updated to reflect the specifics of the case and everything like that. And there will also be a playlist for that trial as well. So do join us for that coverage if you are interested. I think it'll be a really good one, and it'll be something completely different. Like I said, has not been done. So with that being said, let's jump right on into these documents. Alrighty, so first we have State of Idaho versus Bryan C. Kohberger, defendant's witness and exhibit list for motion for change of venue. Comes now Bryan C. Kohberger by and through his attorneys of record will call the following witnesses and intends on offering the following as evidence at the motion for change of venue hearing on August 29th, 2024, although not necessarily in the same order as listed. By the way, I will cover this hearing. That probably goes without saying because, ever since I decided to start covering this, I've covered everything of it. But just in case, right? So if you are following this case, make sure you are subscribed, and there's a playlist as well for everything. Again, once I decided to start covering it, I've not missed a document or a hearing. So we will cover this as well. So we have here these witnesses. I'm just, for the sake of not butchering names, I'm just going to say Bryan, Edelman, et al. Exhibit disclosures. Exhibit A, MPD press releases. That's Moscow Police Department. Motion for filing under seal pending. Live press releases and interviews to be hand-delivered. Exhibit B, that's a declaration from Dr. Edelman and CV, I guess his curriculum vitae. Motion for filing under seal pending. PDF of the PowerPoint. Oh boy, we love a good PowerPoint. Survey analysis and list of local media stories to be hand-delivered. Exhibit C, true scope infographics and CV of Todd Murphy. Motion for filing under seal pending. List of media stories with links to the actual story to be hand-delivered. Exhibit D, Affidavit of Scott Sundby. Exhibit E, we've got another report with a CV there. Motion for filing under seal pending. Another PowerPoint PDF. Oh boy. And then Exhibit F, another report and a CV. Certificate of delivery. Yep. Okay. So then, moving right along, we shouldn't be surprised at this point, right? Because with every, this is just par for the course. With every time there's another document, right, where it's like, okay, here's some exhibits, here's some discovery, blah, blah. Everything, it always follows immediately that there's going to be things sealed. And that's not weird, you know. I mean, this has been happening on both sides, from the prosecution and the defense. Okay, so here we go. So, stipulated motion to seal exhibits comes now Bryan C. Kohberger, buying through his attorneys of record, and with a no objection in quotations. This is so funny. In other words, and I believe we heard that at the last hearing, was it, or maybe the hearing before, where they said they wouldn't have an objection. So they're like literally quoting them. Like, this is actually funny because it's like literal. Like, they said they weren't going to object, Your Honor. From the Latah County Prosecutor's Office, and hereby moves this court for an order to temporarily seal portions exhibits to seal portions exhibits. Interesting. I think that might be a typo. Portions of exhibits to the memorandum in support of motion to change venue. The portions of the exhibits to be sealed are contained another typo. I have to say this, okay? I read a lot of court documents, but I have not seen any typo that I can think of from any filings from the defense since I started covering this. So this is actually really fucking surprising. The portions of the exhibits to be sealed are contained this is throwing me for a loop here. Contained in the USB flash drive that was hand-delivered on 7/22 with a copy of the defendant's witness and exhibit list for the motion for change of venue hearing pursuant to I.C.A.R 32. Speaking of I.C.A.R, the parties agree that the sealed portions of the exhibits will be utilized in open court on August 29th, 2024 at the hearing on defendant's motion to change venue. So basically, this is the hearing. Like I said, we'll cover it right here, August 29th. It was distracting because of the typos, but basically what this is saying is that what they're talking about here, the stipulated motion to seal exhibits, okay, the portions that are going to be sealed were contained in this flash drive, right? And they agreed that it would be sealed until the hearing, when they're utilized in open court. And this makes sense because it looks like it was going to be, what was it, like the PowerPoint presentations? Essentially, okay, you've got these people, right, and these are the exhibits. And the point is that these exhibits are going to be presented on August 29th. Yeah, all right. So it's going to be utilized in open court. There we go, on August 29th, at the hearing on the defendant's motion to change venue. That all sounds good to me. Every time I click it, it does that. This motion is made pursuant to I.C.A.R 32. I swear, I.C.A.R. Y'all, if I had a penny for every time I've said I.C.A.R in the past, 6 months, I would have some amount of money. I.C.A.R 32, I2D, and E, and I.C., that's Idaho Code, and there's the statute. Because the documents contain facts or statements that might threaten or endanger the life or safety of individuals, it is necessary to preserve the right to a fair trial, and disclosure would constitute an unwarranted invasion of personal privacy. So there we go. Okay. All right, now everybody, make sure you're sitting down. Make sure you have been hydrated. I don't know. Do things. Because this is 319 pages. Okay. Now, let's see what was going on here. Memorandum in support of motion to change venue. So my guess is that a lot of this is going to be exhibits. All right. Comes now Bryan C. Kohberger, buying through his attorney's record, and hereby submits this memorandum in support of motion to change venue. This motion is based on the 5th, 6th, 8th, and 14th Amendment to the, shouldn't say amendments, to the United States Constitution, and Article 1, and then these are the specific statutes within the article: 1, 6, 7, 13, and 18 of the Idaho Constitution, Idaho Criminal Rule 21, and Idaho Code 19-1801 et sequitur, and supporting case law. This memorandum is supported by exhibits. There we go. Exhibits. Yes. Referenced herein, and attached witnesses will be called at the hearing. Yes. And August 29th, we will be there. Mr. Kohberger is protected under the constitutions of the United States and the state of Idaho. His protection to a fair and impartial jury is infringed without a change of venue. A fair and impartial jury cannot be found in Latah County because of the extensive publicity that is ongoing and inflammatory. The inflammatory nature of the publicity has included inaccurate information and inadmissible information. The publicity has been extremely pervasive in the small community of Latah County. Remediations such as enlarging the jury pool will not cure the problem. So I will say that the initial hearings that they had with their expert discussing this change of venue, it got real spicy. Literally, it was immediately following that hearing that I was like, I have to cover this. And honestly, people probably got sick of hearing me talk about that hearing because I thought that hearing was so fascinating. I almost went back and covered it because that was really when I was like, I can't not cover this anymore. That was the turning point for me. So I still have thoughts about maybe I should still go back and cover it. But anyway, because I thought it was so fascinating what we learned about this entire process and how it works with like, I don't know, there was a lot of psychology involved. Anyway, I'm sure you guys have seen it. And I think that we all kind of had maybe expectations, or I know I had expectations of maybe what was going to be presented and what the arguments were going to be and what, blah, blah. And it was really not at all, like, there was a lot more to it than what I thought it was going to be. So, anyway. Okay. Issues. 1. Bryan Kohberger cannot receive a fair trial in Latah County as protected by his rights under both the United States and Idaho constitutions because of the pervasive, inflammatory, often inaccurate, and highly prejudicial publicity and the small size of the jury veneer. If you are in South Carolina, you might hear them say veneery. 2. A change of venue is necessary under Idaho Criminal Rule 21 and Idaho Code 19-1801. Abbreviated factual background. All right, let's see factually just how abbreviated this really is. Media coverage of the case that later became State v. Bryan Kohberger began in the early afternoon. Oh boy. Since the dawn of time. No, I'm just kidding. I feel like we're kind of almost there. Early afternoon of November 13th, 2022. When news broke of 4 homicides in Latah County, Idaho. Extensive media coverage ensued for 6 weeks during the police investigation prior to the arrest of Mr. Kohberger. Daily updates were available from Moscow Police Department, hereinafter MPD. Often participating in the updates or press releases was the Latah County prosecutor and chief of police, James Fry. These broadcasts were played on television news stations as well as print and digital media. Social media covered the investigation, with MPD updating its Facebook page and providing press releases and media statements regularly. See Exhibit A, MPD press releases. MPD's investigation included law enforcement partners from Idaho State Police and the FBI. Media coverage, particularly in the market covering Latah County, was replete with story after story. In local newspapers and news stations, media focus did not stop with locally targeted news stations or newspapers. It extended into magazines, books, crime TV shows, and the current medium of information and opinion sharing, the internet. Immediately and consistently, the internet was abuzz. That's a good word. Abuzz with podcasts, tweets, they say. Is it still a tweet? I have to say, I've never had Twitter or X, never had it, never used it. I'm just wondering, is it still actually a tweet, though? Like, I know people should call it a tweet, but, like, is it supposed to be called something else? I don't know. Anyway, tweets, Facebook groups, Reddit, YouTube, and TikTok postings. Shout out to YouTube. Once the police arrested Mr. Kohberger, the public was ready to, and has, proceeded to vilify him without regard to the constitutional guarantee of the presumption of innocence and a right to an impartial jury and fair trial. The media focus on Mr. Kohberger has been relentless and highly inflammatory. I will just say, I do feel like just from what, even just, on YouTube, right? I do feel like you hear less about this case than you used to. Let me know what you guys think in the comments. If you feel like you're still seeing just as much coming out, of course, again, there's channels like mine that are going to cover whenever there's a hearing or a court filing, but it used to be there was stuff like all the time, all day, every day, right? And so now, even if you've got people covering every, whenever there's a new court filing or hearing, that's still periodically, right? That's not like an influx, if you will. Like, I don't know that it's as relentless. I mean, even when they set the trial date, y'all, that was during that was during Karen Reed and maybe during Baldwin, but there was so much going on in other trials that I remember thinking it was crazy because it seemed like kind of everybody just kind of missed it. It's like had that happened at some other time, it might have actually, maybe then it would have received all this coverage. But it's almost like just kind of just flew under the radar because there was just too much other shit going on. So while I know that's what they would maybe prefer, it doesn't actually help their argument, right? If they want to support the argument for change of venue, this case needs to continue to receive relentless and highly inflammatory coverage, right, in the media. And if it doesn't, even if it's just because there's other cases that there's shit going on, right, then how does that affect their argument? Well, let's find out when we get to the next portion, which is called argument. All right. Bryan Kohberger cannot receive a fair trial in Latah County as protected by his rights under both the United States and Idaho constitutions because of the pervasive, inflammatory, and often inaccurate publicity and the small size of the jury veneer. The great value of the trial by jury certainly consists in its fairness. Yeah, so it's just funny. Like, the reason I laughed, right, is because the first couple words that I read, and then I laughed, I'm like, oh my God, what is this going to be from like the 1800s? And then I looked down and sure enough, 1807. Love it. Shout out to history. The great value of the trial by jury certainly consists in its fairness and impartiality. Those who most prize the institution prize it because it furnishes a tribunal which may be expected to be uninfluenced by an undue bias of the mind. I have always conceived and still conceive an impartial jury as required by the common law, and as secured by the Constitution, must be composed of men and women who will fairly hear the testimony which may be offered to them and bring in their verdict according to that testimony, according to the law arising on it. Squirrel thoughts. I wonder if there's a time when women could not serve on a jury. The Supreme Court in an 1879 decision confirmed that a state may constitutionally, quote, confine the selection of jurors to males, end quote. Utah in 1898 became the first state to deem women qualified for jury duty. But as of 1927, only 19 states allowed women to serve. Aside from the, quote, defect of sex, end quote, no comment, women were excluded from juries for a variety of reasons. Their primary obligation was to their family. I knew it was going to say this. The families and children. Hold on, let me guess. Is it going to say something about their mood or that time of the month? Like, what else are they going to say? They should be shielded from hearing you've got to be fucking kidding me. Shielded from hearing the details of criminal cases. Oh, God. Particularly those involving sex offenses. Wow. They would be too sympathetic to persons accused of crimes, and keeping male and female jurors together during long trials could be injurious to women. What do they mean by this one? Like the men are going to hurt the women? Anyway, all right. As late as 1961, the Supreme Court, in a unanimous decision, upheld a Florida law automatically exempting women from jury service. According to the court, despite the enlightened emancipation of women from the restrictions and protections of bygone years, and their entry into many parts of community life formerly considered to be reserved to men, woman is still regarded as the center of home and family life. We cannot say that it is constitutionally impermissible for a state acting in pursuit of the general welfare to conclude that a woman should be relieved from that civic duty of jury service unless she herself determines that such service is consistent with her own special responsibilities. What the Supreme Court is saying here is that the Supreme Court is saying we can't constitutionally say it's impermissible for a state to draw their own conclusions that a woman should have the right to choose or whatever, where her own responsibilities lie. The ACLU, as part of its program to desegregate the judicial system in the South included claims on behalf of women in cases it brought to stop racial discrimination in jury selection. In one of those cases filed in Georgia in the early 1970s, we challenged state laws that excluded women from serving on juries and allowed them to opt out of jury duty. Another challenged law allowed a woman to be excused from jury duty if, quote, she is a housewife with children 14 years of age or younger, end quote. The plaintiffs included 3 women who had been excluded because of their gender from jury service. The exclusion of women from juries was challenged both as denying women the equal protection of the law under the 14th Amendment and as denying criminal defendants the right to representative juries drawn from a fair cross-section of the community guaranteed by the 6th Amendment. Yeah, that's a great point. From both ends, from both sides, this is a constitutional issue here. As the Supreme Court explained, quote, community participation in the administration of criminal law is not only consistent with our democratic heritage, but it is also critical to public confidence in the fairness of the criminal justice system, end quote. In response to the litigation and subsequent decisions of the Supreme Court, the Georgia legislature repealed the provisions of state law that excluded women from serving on juries and that allowed them to opt out of jury duty. Not allowing women to serve on a jury, or even allowing them to opt out, right, is not just infringing upon the women's 14th Amendment right, but of course there's that other factor of the criminal defendant's 6th Amendment right. So by allowing them to opt out, you might be solving potentially the first issue with the women's 14th Amendment, but not with the 6th Amendment, right? Because that's the whole thing. They deserve to have a jury of their peers. So this makes complete sense that you can't allow them to opt out, right? It needs to be equal. Okay, and later, dropping the gender distinction, the state amended the law to allow any person who was the primary caregiver of a child 6 years of age or younger to be excused from jury duty. There you go. We have come a long way in shedding the condescending and demeaning characterization of women as unfit for discharging one of the basic functions of citizenship. Serving on juries that resolve important issues of public law, and we have helped dismantle this. Well, this is just them tooting their own horn. Anyway, okay, I think we've learned a lot. We've learned things, as I will say, because Learnin Is Squirrelin. So now let's get back to the court filing here. So after that little jaunt, we can say that here from this case law, 1807, where they say must be composed of men. Yep, that's accurate. So there you go. He will fairly hear the testimony which may be offered to them and bring in their verdict according to that testimony and according to the law arising on it. This is not to be expected. Certainly the law does not expect it, where the jurors, before they hear the testimony, have deliberately formed and delivered an opinion that the person whom they are to try is guilty or innocent of the charge alleged against him. And there's that case law from the good old year of 1807, a very fine year. The United States Constitution, through the 6th and 14th Amendment and the Constitution of the State of Idaho, Article 1, Section 7, guarantee an accused with a fair trial and an impartial jury. The constitutional mandate of a fair trial by an impartial jury requires a change of venue where an impartial jury cannot be impaneled in the district where the indictment is returned. Quote, due process requires that the accused receive a trial by an impartial jury free from outside influences. Where there is reasonable likelihood that prejudice in a community will prevent a fair trial, a change of venue should be granted. Consequently, the question posed by a motion to change venue is whether a reasonable likelihood exists that pretrial publicity has affected the impartiality of prospective jurors. The phrase reasonable likelihood denotes a lesser standard of proof than more probable than not. All right, the determination of whether to grant a motion for change of venue is addressed to the discretion of the trial court. In exercising this discretion, the trial court must keep in mind that although the mere presence of pretrial publicity is not enough by itself to warrant a change of venue, a defendant's inability to make a detailed and conclusive showing of prejudice is not a proper ground for refusing to change venue. Prejudice seldom can be established or disproved with certainty. And I feel like that was one of the points that they talked a lot about during that spicy hearing I referenced earlier. Here's some more case law. A showing of actual prejudice shall not be required. Any doubt as to the necessity of removal to another county should be resolved in favor of a change of venue. Okay. Prejudice may properly be presumed when either A, inflammatory publicity about a case has so saturated a community that it is almost impossible to draw an impartial jury from that community, or B, So many jurors admit to a disqualifying prejudice that the trial court may legitimately doubt the avowals of impartiality made by the remaining jurors. Publicity by itself does not require a change of venue. However, a presumption of prejudice requiring a change of venue attend only the extreme case. The test for the extreme case remains whether the trial atmosphere has been utterly corrupted by press coverage. Interesting. That's from 2012. Mr. Kohberger is not on the eve of trial, thus no actual jurors will be called in to determine prejudice. Instead, extensive surveys show actual prejudice and how State v. Kohberger is an extreme case where a venue change is required. It is not possible to impanel an impartial jury in Latah County based on the pervasive and inflammatory press coverage. See Exhibit B. Letter A. State v. Kohberger is an extreme, in italics, case in that the atmosphere, Latah County, that's a weird sentence. State v. Kohberger is an extreme case in that the atmosphere, Latah County, is utterly corrupted by press coverage requiring a change of venue. I wonder if there's another typo in here. That just seems weird. And why is atmosphere capitalized? Anyway, Bryan Christopher Kohberger, once arrested. Why did they... This is a weird time to all of a sudden type out his middle name in full, right? We already know. Anyway, it's just funny. It's like not necessary. Bryan Christopher Kohberger, once arrested, quickly became a recognized... Oh, never mind. Keep reading, Chelsea. Quickly became a recognized name. Actually, I feel like it was more like the C, right? The investigation into the deaths of 4 college students had captured the attention of the community, the state, the country, and even beyond the United States. Sorry, I expected this to say the attention of the community, the state, the country, the galaxy, the whole universe. Yeah, that's what I was expecting. Anyway, even beyond the United States, long before the arrest of Mr. Kohberger. Since his arrest, interest in the charges, who he is, and his background continue rather than fade over time. I don't know. I feel like it's been fading, but again, I'm not one of those people who's really, you know, in the know with like what the kids are doing these days. There's a perfect example right there. The continuous nature of media coverage, often inaccurate and misleading, the impact of the media coverage, and the small size of the community make the case against Mr. Kohberger extreme. Media saturation in Latah County has been continuously heavy since the deaths were reported. Public interest in the case does not wane. Again, you know, just from my corner of the world, right? Whatever I was seeing about it before, when I feel like I was seeing stuff about it all the time, right? It's probably less than it was. So I don't know. I feel like it is waning. Again, that's, in a way, it's a good thing for them, but in a way it's not, because they need to make this argument to get a change of venue, right? So, interesting. Stories about the case and Mr. Kohberger come in the form of published books. That's true. There is a book coming out, I think, or maybe it already came out. Television crime shows, internet platforms, social media, news stations, and newspapers across the nation. The most coverage from these sources has occurred in Latah County. Coverage runs the gamut, reporting on items containing court filings, to reporting about what unnamed sources have said, as well as reporting based on other media stories. I mean, the thing is this. Here's where I would push back on this, because these attorneys, when I say these attorneys, I mean all the attorneys, right? But in this case, we're talking about the defense attorneys. They know that when they make a court filing that's not sealed, it's public record, and they know people are going to cover it, right? And in fact, this is a strategy that we've seen these very attorneys use, and attorneys in other cases, where, and especially when there's something like a gag order in place, they actually will use court filings as kind of a way to get some sort of narrative out into the media, right? Which is, you know, whatever. It's a way around it. Like, in other words, what my point is, I guess, that at the same time, I think that they actually are grateful for the fact that they can make, you know, these statements or make a suggestion in a court filing, knowing that people are going to cover it, and therefore their message will still get out to the media without them breaking the gag order. A, it's better than people giving misinformation, right? Because it's actually accurate information. B, they are fully aware of that, and they use it as a strategy oftentimes, and they have done that to their advantage. So anyway, all right. Containing court filings to reporting about what, quote, unnamed sources, end quote, have said, as well as reporting based on other media stories. These stories are often rife with misinformation and speculation. The amount of media stories, the inaccurate and speculative nature of the stories, and the impact on potential jurors show that State v. Kohberger is an extreme case. Now, see, my inclination here is the same as what we've heard before from the judge, which is which was one of the things I really thought was so interesting about that hearing, this concept of what is public record, right? Because the way the court views public record is anything that is a court filing, like a legal, the shit that I cover, right? Court filings, hearings, right? Public court record. But as we learned, when it comes to this niche area of assessing a jury pool, public record is whatever's in the fucking public, right? And nobody has any control over that, really. So, but I do think it's important, as Judge did, right? At this hearing, Judge made it very clear he did want to differentiate from now henceforth when we say public record. Here's how I mean it, blah, blah. I feel the same way. I don't think that reading a court filing, or a legal document, or watching a hearing, that is not in the same category, in my mind, as a story rife with misinformation and speculation. Now, I understand that I'm biased, but whatever. I see that. I still think it's an important distinction. So anyway, the amount of media stories, the inaccurate and speculative nature of the stories, and the impact on potential jurors show that State v. Kohberger is an extreme case. The impact of this vast media coverage on a potential Latah County juror demonstrates the necessity of venue change. Media from locations outside of Latah County is easily accessible to a potential juror. However, Latah County residents have received the most media saturation within the state. Yeah, they're very clear about that. And then Exhibit C, which we will take a look at. TrueScope is a media collection company, and based on the analytics completed by the company, media coverage directly in Latah County makes up 36.13% of the coverage in the entire state. The statistics indicates, again, I think that there's another typo here. I should say the statistic indicates, or the statistics indicate that this is 36.13% of traceable media. That means newspapers and television. See Exhibit C. More than 1/3 of the total print and news coverage is centered in Latah County. More than 1/3 of the traceable media in one county is astounding. However, considering that Latah County comprises only 2.75% of the entire population of Idaho, the oversaturation and resulting prejudice is magnified. The prolific media coverage in Latah County is not a mere passing story. The content is not benign, rather it is inflammatory, evoking, and often misleading, false, and poorly sourced. There is no reasonable belief that media coverage will slow, regardless of how long the case takes to prepare for trial. Well, we have a date now, so there will be no elapsed time between media coverage and jury trial. In Exhibit C, TrueScope depicts a visual of peaks and valleys in coverage rather than a continual decline. The valleys followed by a spike correlate with hearings or court filings in the case. Okay, yeah, well, there you go. Based on the pattern depicted in Exhibit C, it is not reasonable to believe a decline prior to trial will occur in Latah County. Media coverage, while extensive, must also be prejudicial. So what they're saying is it can't just be extensive coverage, it has to be prejudicial. The prejudicial effect of the Latah County media coverage is shown based on survey work performed and analyzed by Dr. Bryan Edelman, Trial Innovations, see Exhibit B. Dr. Edelman constructed a survey to test the effect of publicity in this case. The survey consisted of questions related to case recognition in general, specific information recollection, and impact for prejudgment. This type of tool is widely accepted within Dr. Edelman's scientific community. Analysis of the community attitude survey conducted by Trial Innovations demonstrates that Latah County citizens who are over the age of 18 are biased and have knowledge of information that is inflammatory, misleading, and or false about this case. The community attitude survey shows case recognition is 98%. 70% of those recognizing the case have already formed an opinion regarding Mr. Kohberger that their opinion is that he is guilty. The survey shows that of those that have the opinion Mr. Kohberger is guilty, 51% state they have a fixed opinion. That means nothing will change their opinion. This is demonstrative of the prejudice discussed in Haddon, as the survey results show both presumed prejudice and actual prejudice in Latah County. The threshold in Idaho is reasonable likelihood, as the court in Haddon stated. It is sufficient for the accused to show there was a reasonable likelihood prejudicial news coverage prevented a fair trial in violation of the Sixth Amendment to the United States Constitution. And I believe this case law, I believe Dr. Edelman also brought this case law up during that spicy hearing. In order to distinguish the media impact on Latah County residents, comparison surveys were conducted in 3 other counties in Idaho. The comparative surveys, while showing high case recognition rates and similar prejudgment of guilt rates, have important differences of lower recognition of media items. Inaccurate media items have a high link in potential prejudgment opinions of guilt. And let's see footnote 1. And this actually, I do again remember them discussing in that spicy hearing. It's just how I'm going to refer to it from now on. So this is from Exhibit 2, Dr. Edelman's Survey and Declaration, media item, quote, have you read, seen, or heard that Bryan Kohberger was staking, again, that's a typo, that should say stalking, holy mackerel, stalking one of the victims, end quote. It's actually not even a quote if it's misspelled, but whatever, is correlated to a high guilt rate. This media item was acknowledged as false by the state in a prior hearing. The knowledge of that media item was higher in Latah County than other counties. So there you go. Additionally, comparative county surveys show a lower number of people following the case have fewer personal connections. It is noteworthy that outside of Latah County, the incidence of fear associated with the case is significantly reduced. The United States Supreme Court also distinguished between jurors' quote, mere familiarity with the defendant and an actual predisposition against him, end quote. Dr. Edelman's survey work shows actual predisposition against Mr. Kohberger in Latah County. One of the primary considerations in determining the pretrial publicity and corruption of a community for venue is the, quote, size and characteristics of the community in which the crime occurred, end quote. Latah County, Idaho, is a small, tightly knit community. Based on survey results, it is a community with a prejudgment for conviction and death sentence. The population of Moscow is only 41,000 people, and of that, 19% are under the age of 18, making them ineligible to be a juror. 19% are over the age of 65, all but approximately 2,000 of whom may request to be excused on the basis of age, those over 70 years old. We have another footnote. The census statistics reduce the eligible population on age alone by 38% for a total 25,000 available population. Yeah, that's not very many. Before any juror qualifications questions are asked. Ada County, 12 times larger than Latah County, provides a greater hope of seating an impartial jury. The small size of Latah County is further challenged by connections to the case that do not exist in other counties. Some of the major employers in the community are people connected to law enforcement and the University of Idaho. The university is the single largest employer in the community. That right there is actually noteworthy to me. I mean, all of this is noteworthy, obviously, but that I don't think I knew. Or if I knew it, I forgot it at some point. But that is interesting. I'm going to highlight that here. The university is the single largest employer in the community with at least 4,517 employees. Wow, that's like, okay, that's almost 20%. That's crazy. That's crazy. That's crazy. That's crazy. The county and city who employ law enforcement, court staff, and jail staff have more than 300 employees. The controlling precedent of the United States Supreme Court in Patton v. Yount and Shepard v. Maxwell hold that upon the showing of abundant evidence in the record demonstrating media saturation in a small county with facts about the case, false information about the case, and otherwise inadmissible material, a change of venue is appropriate. In Shepard, the Supreme Court held that due process requires a change of venue or a continuance when the defendant can show a reasonable likelihood that prejudicial news prior to the trial will prevent a fair trial. More specifically, because a criminal defendant has the right to an impartial jury, a court must grant a motion to change venue if prejudicial pretrial publicity makes it impossible to seat an impartial jury. The United States Supreme Court distinguishes between publicity that is largely factual publicity. Interesting, because remember what a big deal they made about the prosecution doing that press conference where they encouraged people to read the probable cause affidavit, and that which is insidious or inflammatory. Of importance is the small community impact on the juror. Jurors sitting on a trial in Latah County will have no anonymity. In a town where calls by a surveyor result in reports to the prosecution and police, there is no doubt that everyone will know who the seated jurors are if this trial is not moved. Jurors will be under immeasurable pressure to reach a guilty verdict and then a death verdict. The affidavit of Scott Sunby in support of this motion states, 2 distinct dangers arise from holding a capital trial in a small community where the victims of the high-profile murders are local residents. The first is that jurors will be distinctly aware of community outrage, and as a result, some are likely to fear that many of their neighbors and coworkers will ostracize them if they do not return a sentence of death. See Exhibit D. Mr. Stuntby asserts that based on over a decade of research and hundreds of interviews of death-qualified jurors, the pressures of deliberations in a capital case in a small community are different and carry unique pressure. I believe that. This survey analysis bears this out in Latah County, see Exhibit B, and we'll take a look at these as well. The lasting impact of extensive media coverage cannot be undone through the voir dire process. Again, another typo. Wow, this is crazy. This should say there is enough. Wow. Like, okay. I'm sure there's even mistakes that I'm missing because my brain is correcting them. So I've pointed out a number of these mistakes, but wow. There is enough evidence to presume prejudice incapable of remedy in Latah County. As the Supreme Court stated in 1908, bias or prejudice is such an elusive condition of mind that it is most difficult, if not impossible, to always recognize its existence, and it might exist in the mind of one, on account of his relation with one of the parties, who was quite positive that he had no bias, and said he was perfectly able to decide the question wholly uninfluenced by anything but the evidence. Well, yeah, of course, everyone's going to say they're unbiased, but how do they know? I mean, that's true with anybody, though. There's no way to test that. Like, you know what I mean? Like, anyway, can't get inside someone's head. Ooh, this is interesting. The influence that lurks. It's lurking, you guys. The influence that lurks in an opinion, once formed, is so persistent that it unconsciously fights detachment from the mental processes of the average man, and psychological impact requiring such a declaration of ability to be fair and impartial before one's fellows is often its father. Is this like a Star Wars reference? Where so many times admitted prejudice, such a statement of impartiality can be given little weight. Wow, that is very interesting. Certainly the citizens of Latah County would mean well upon a promise to set aside information gleaned via the media and conversation with others. However, this is an often unknown mindset that new information filters through. Further unknown biases exist that cannot be corrected for. Yeah, but that's going to be true anywhere. In Delaney versus United States, the court recognized the difficulty of assuming that the average juror may confidently exclude even the unconscious influence of his preconceptions as to probable guilt engendered by a pervasive pretrial publicity. Claims of impartiality should be rejected where prejudice is widespread. Another case law citing here, when a high percentage of the veneer admits to a disqualifying prejudice, a court may properly question the remaining jurors' avowals of impartiality and choose to presume prejudice. So they're saying, like, if a vast majority of them seem to have problems, then maybe everybody does, kind of thing. Like, again, it's like, it seems like it's a pervasive prejudice, would be the way I interpret that. In a community where most veneermen will admit to a disqualifying prejudice, the reliability of the others, protestations may be drawn into question, for it is then more probable that they are part of the community deeply hostile to the accused, and more likely that they may unwittingly have been influenced by it. Yep. Social science research confirms the inadequacy of voir dire as a remedy in a case such as this. This doctor here states the impact of media coverage causes a potential juror to have a preset opinion about Mr. Kohberger that provides a backdrop for new information that likely will be interpreted to confirm already formed beliefs. Right, so confirmation bias. Additionally, the impact is increased because much of the initial information has come from authority figures. This early information was accompanied by emotions, which deepen preset opinions. A good example specific to the population of Latah County comes from the University of Idaho president, Scott Green. He published a book with a chapter entitled, quote, When Evil Visits Your Campus, end quote. Yeah, that's problematic, and I knew that when dude, I've had to sit that book out of my mind because I was like, this isn't good. This isn't good. Why is he doing this? Yeah, that was bad. Dude, that's a whole other thing. He dedicated the book to the victims and claims that proceeds from the book are being used to create a memorial garden. In his book, President Green tells of the great fear that existed on campus and in Moscow. He writes about self-defense classes and counseling that goes on to this day. Dude, self-defense would not have saved those kids. Just saying. He expresses how the community came together, bringing several thousand residents to a candlelight vigil. He explains how his close work with law enforcement during the months after that crime helped him make decisions. He shares in writing his theory about Mr. Kohberger's guilt. The impact of the message from a community leader in a highly emotional atmosphere creates a level of strong potential for bias non-existent in other Idaho counties. Again, I think that, going back to what I said just a few minutes ago, that little tidbit about how the campus, University of Idaho, employs almost 20% of just the eligible jury pool when you take the entire population and you just remove those who are too young or too old, and that's what you get is, 25,000 people, and the university employs, 4,500 of the 25, like, that's insanity. I would lean more on that if it were me, but I don't know anything. So, all right, 2, change of venue is necessary and appropriate. So I don't know, I think they could have mentioned that again here in reference to this Scott Green book situation. 2, change of venue is necessary and appropriate pursuant to statute and rule. Idaho Criminal Rule 21 and Idaho Code 19-1801 provide direction to the court to change venue upon finding an impartial jury cannot be had in the county where the indictment was found. The foregoing argument related to constitutional protections apply with regard to Idaho Criminal Rule 21A. Without repeating those arguments, we turn to appropriateness of venue change pursuant to Idaho Criminal Rule 12B, authorizing a court to change venue for other reasons. Idaho Criminal Rule 12B allows the court to transfer the proceedings to another county for the convenience of parties and witnesses and in the interest of justice. The court should consider, along with the foregoing, these additional factors available with a change of venue to Ada County. Oh, good old Ada County. Ada County is the largest county in Idaho with more than 10 times as many potential jurors than Latah County. Given the familiarity with the case throughout the entire state of Idaho, selecting an impartial jury as guaranteed by the Constitution will be a challenge. The best chance to find an impartial jury is to have the largest potential pool of candidates. The Ada County Courthouse can accommodate this trial. There are large courtrooms with adequate space for the attorneys and Mr. Kohberger. Like he's not larger than a courthouse, okay? The large courtroom provides space for each counsel to keep materials and necessary conversation out of eyesight or earshot of the other party, spectators, and the media. Due to its size, the courtroom can accommodate a large number of spectators, and there's overflow space available for the public to watch the trial. So I think maybe, I don't know, this is just, I'm saying this half as a joke because honestly this might even not be a joke. This might be accurate. But I wonder if part of this is like trying to like just like say, hey, look, like this is good for everybody, like including the media. You guys want to see the trial? We've got room for you here, you know? That makes sense. Like, I don't know. That's interesting, right? Ada County has adequate security for the safety of the parties, court staff, and jurors, and we've heard the bailiffs are lovely from other trials that have been held there. There are multiple jury rooms and many private restrooms away from the public to accommodate a large jury for several months. The courthouse and security are set up to assist jurors to and from the courthouse without media exposure. Any consideration related to costs of the prosecution and defense make Ada County a logical choice with the largest airport in the state. Right, we do, and that's another thing, right, it's closer to the airport. There will be a number of witnesses traveling into Idaho, and Ada County is a more cost-effective. There will be a number of witnesses traveling into Idaho, and Ada County is a more cost-effective option. The Moscow-Pullman Airport has few direct flights, especially in the summer months. This will require more witnesses to travel to Spokane, Washington, and rent a car to drive to Latah County Courthouse. Another consideration for this court pursuant to Idaho Code 19-1801 is that Chief Fry is running for Latah County Sheriff. Oh boy. Yeah. I think that's a good one. I would say, apart from just the obvious things of like people hearing things in the media, I would say the whole thing about, again, the university employing almost 20% of the eligible jury pool, this I would say is number 2 for me. This is insane. I also did not know this, that Chief Fry is running for a sheriff. Yeah, that could be, that's a thing. That's a thing. Chief Fry is a witness in this case. He has engaged in extensive media statements. Yeah, he's politicking, right? He's running for office. It'd be different if he was elected. He's running for office. If he's elected, his position statutorily gives him power to summons jurors if directed to do so and to be in charge of an impaneled jury. Oh, okay. If he is elected, a conflict is created in his statutory duty to be in charge of an impaneled jury when he's a witness in this case. Yeah, this is one of those, quote, interest of justice, end quote, factors that supports a venue change out of Latah County. Yeah, I agree. You know, I almost feel like they have so many points to this. You know, I understand giving as many reasons as possible because I know it's really difficult to get a change of venue. However, I almost feel like personally this could be almost stronger if they just this is just my personal opinion, you know, given that I feel like the media bias is, it's sort of like they've already argued that and shit. I almost feel like this could be stronger if they had just stuck with, gone straight to what I feel like are their strongest additional points, which are about the university and this Chief Fry running for sheriff. Like, you know what I mean? It's like, it's almost, I almost feel like these could be, well, it weakens the impact of some of these other, this new information, right? When for so much of the beginning of this entire document, it was sort of repeating what was already known to the court, right? And to us also, but more importantly to the court. So, you know, start with your strongest arguments, you know what I mean? Anyway, okay. Conclusion. This is no ordinary case. Bryan Kohberger is accused. That's, for anyone who's listening, that's in caps and bold, the word accused. Accused of killing 4 individuals. The state seeks the death penalty if the trial should result in conviction. As such, Mr. Kohberger's constitutional rights must be carefully guarded. Rarely does even a small community come together in both number and quality of unity, as has happened here. Latah County is in all regards a nice, quaint, close-knit community that sticks together. While a small, close-knit community is what is hoped for in a small town, constitutional rights must still be carefully protected. Mr. Kohberger has the right of a presumption of innocence. He is guaranteed the protection of a fair jury and due process of law. Given the level of bias in Latah County, Mr. Kohberger cannot receive a fair trial. An impartial jury is in this community cannot be picked. The court must protect Mr. Kohberger's constitutional rights and grant a change of venue. There you have it, people. So now we have 300 pages of exhibits, or sorry, 306 pages to go of exhibits. So the next like 100 to 200 pages is literally this. It's all the press releases. And I think the point is just to show how many of them there are. These, I'm sure, if you're watching this video and you're following this case, we learned of all of these as they happened in real time. These go all the way back to the very beginning, blah, blah, blah. It's every time there was a press release, and as we know, there were a ton of them. So none of this is new information. This is all very old information. I think the point, again, is just to show the quantity. So we're going to go past this until we get to the more interesting part, which is Bryan Edelman's statement. Aha, here we go. All right, declaration of Bryan Edelman, Ph.D. I, Bryan Edelman, solemnly, sincerely, and truly declare and affirm as follows. Introduction. I am the co-founder of Trial Innovations Incorporated, a national full-service jury research firm. I have worked as a trial consultant for 20 years and have conducted pretrial and post-trial research on both criminal and civil cases across the country. I have been retained as an expert in over 70 cases that have received significant publicity and asked to assess the impact of media coverage on the fairness of the trial proceedings. Some of the cases I've been retained on include State of Idaho versus, I'm not going to read all these, counsel for the defendant in State of Idaho versus Bryan Kohberger retained me to research and evaluate 1, whether there was extensive and prejudicial pretrial publicity in Latah County surrounding the killing of 4 students attending the University of Idaho in Moscow, the community panic that ensued during the search for a suspect, and the alleged evidence tying Bryan Kohberger to the murders. 2, determine if the media coverage has impacted the defendant's ability to obtain a fair and impartial jury in Latah County. 3, evaluate potential bias in alternate venues. And 4, based on the findings, recommend appropriate remedial measures, for example, a change of venue, to protect the Kohberger's ability. Y'all, I'm reading this correctly, just so you know. To protect the Kohbergers. That seems like he was maybe trying to decide between the defendant and Bryan Kohberger and got his wires crossed. Again, I'm still just baffled that there's another problem with this document. The Kohberger's ability to be tried by a fair and impartial jury. As part of my analysis, I evaluated relevant news, print, television, and social media coverage surrounding these events and conducted a community attitude survey of 400 residents in Latah County. Comparison surveys were conducted in Ada, Canyon, and Bannock counties. It is my opinion that the residents in Latah County have been exposed to extensive prejudicial pretrial publicity and social media surrounding the murders of Kaylee Gonsalves, Madison Mogan, Zeno Kernodle, and Ethan Chapin. The coverage of Bryan Kohberger included interviews with former friends and students and old posts from his social media accounts dating back to years. This publicity painted a picture of a disturbed individual capable of committing violence. The media also saturated the jury pool with potential trial evidence and details, some of which prove to be false or misleading, that create a presumption of guilt. The pretrial publicity is replete with references to GPS phone data from the defendant's phone, video footage of the alleged getaway vehicle reported to be his make and model, evidence left by the killer at the crime scene, DNA results, and erroneous connections to the victims. Much of this information came directly from the probable cause affidavit shared with the media by Latah County Prosecutor Bill Thompson during a December 30th, 2020 televised news conference. God, was that many years ago? No, he got the year wrong. Hold on, my brain is buffering. He got the year wrong. Did you see how I added? Dude, I said 2022, and then I was like, wait, why am I saying 2022? That says 2020? He got the year wrong. I don't even have words. He got the year wrong. How? 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 Oh my God. He may as well have put a different defendant's name in here, period, instead of the Kohberger. He could have just said Mr. Jones. I mean, this is crazy. He got the year wrong. Incredible. Incredible. With the media in attendance, Mr. Thompson encouraged them to, quote, share the true facts with all of your readers, the watchers, and listeners, and all the people who are interested and really need to know what's going on, end quote. I mean, again, this came up in the spicy hearing, again, you know, where it's like, well, he's not wrong, but also the point was to stop misinformation by giving people facts. And, you know, again, court documents, public record, the way that the court sees it, court filings, right? These killings sent shockwaves through the local community and generated widespread panic during the 6-week search for the killer. During this time, there was tremendous pressure on law enforcement to find the person responsible for the murders and share details about the investigation with the public. With investigators reluctant to share information before making an arrest, rumors and misinformation proliferated via informal communication channels and social media about the crime. For example, the victims were bound and gagged, the killer called 911, and the killer, example, it was a driver who took the victims home, the roommates were involved, Kohberger had killed before. During this time, it was reported that detectives received 2,645 email tips. Why are there no commas? 2,770 phone tips and 1,084 digital media submissions from the public. Residents remained on high alert and feared that the killer could strike again. Many students went home for the Thanksgiving break early and did not return. On December 10th, University of Idaho spokeswoman Judy Walker told the media that an estimated 25% to 40% of the students had not yet returned to campus. One of the victim's sisters encouraged students to go home rather than risk their lives. Quote, to the students at the University of Idaho that are still staying around campus, leave. Your grades are severely less important than your lives, end quote. Police Chief Fry tried to reassure the public that everyone was safe, and the University of Idaho drastically increased campus security. The Moscow community joined together to support the victims and their families. A candlelight vigil was held on campus, and thousands of stickers were handed out. Another candlelight vigil was held on the one-year anniversary of the murders. In addition, a tree that serves as the centerpiece of Moscow's Friendship Square was decorated with messages written by community members to honor the 4 victims during the holiday season. The Healing Garden was inspired by the murders and created to memorialize all students who had died while attending the university. The King Road home where the victims... Oh, God. I'm going to have to not go off on a tangent. I'm just going to keep reading. The King Road home where the victims lived was demolished based on requests from the student body. Quote, we heard from students in the area that they were ready for the house to come down, end quote. However, the decision was met with criticism and fomented another round of speculation and misinformation. A community attitude survey was conducted to assess the impact of media coverage on the Latah County jury pool. Approximately 98% of the survey respondents were familiar with the case. In addition, community members have more than just a passing familiarity with this crime. Approximately 68% of survey respondents reported that they have followed the case somewhat or very closely, with 29% falling into the latter category. In addition, 79% of survey respondents recognized at least 5 of 9 media items tested in the survey, and 52% knew 7 or more. 81% of those familiar with the case had read, seen, or heard that police had found a knife sheath on the bed next to one of the victims, and 67% were aware that DNA found on the sheath was matched to Bryan Kohberger. In addition, 86% of Latah County survey respondents heard that the defendant owned the same type of car, recorded on video driving in the neighborhood where the killings occurred, and 79% knew that cell phone tower data purportedly show that Kohberger made several trips near the victim's home months before the killings. These findings are particularly concerning given that all of these media items, which came from the probable cause affidavit mentioned during a December 30th press conference, at least he didn't say the year and get the year wrong, were significantly related to prejudgment. For example, 72% of Latah County prospective jurors who knew that the police found a knife sheath, and 75% of those who heard there was a DNA match believed Kohberger is guilty of murder. These findings put the defendant at a distinct disadvantage at the start of the trial. Well, okay. They're going to learn this at the trial, right? Like, that's their strongest evidence, the DNA. Like, there's just no way around. They're not, like, every case is going to have a probable cause affidavit, right? Like, you can't just arrest people without cause, right? You have to have probable cause. So the problem inherent there is that because court documents are public, right? In any case, if someone's arrested, I mean, it's worse if there isn't probable cause, right? It's like, it's better that there existed good probable cause than that there didn't exist good probable cause. So it's interesting to me to say, well, there's such damning evidence, essentially, right? Like in the probable cause. I guess what they're trying to say is, well, they connected the fact that there was a knife found and then there was DNA that matched Kohberger. Well, yeah, that's, I mean, that's kind of the point. That's like the prosecution's, I mean, that's a lot of their case, right, is going to be based on that. And the other thing is, if they didn't know it ahead of time, they're going to hear that in opening statements. Give it 5 minutes. Give it 5 minutes, and they're going to hear that in opening statements. So I don't know. I don't think this is their strongest argument here. These findings put the defendant at a distinct disadvantage at the start of the trial. Many of the incriminating details widely reported in the media are in dispute, including the claim that Kohberger's vehicle was placed near the crime scene by video footage and cell tower data. You're right, but what's not in dispute is the DNA. However, the burden of proof has shifted to the defendant, who must change jurors' pre-existing opinions regarding the evidence against Kohberger developed from exposure to biased media coverage. I mean, yeah. Again, I'll say it again. I think for me, the two strongest things they could be focusing on are about how many people are employed by the university and the Chief Fry thing, running for sheriff. The size of the venue is another important factor to consider in this case. Sensational crimes are more likely to have a longer-lasting impact on the public's consciousness in smaller counties than in larger ones where violent crimes are more common. Informal communication channels, including social media, can also have a greater effect in spreading rumors and misinformation in smaller counties. Latah County is the 11th largest county in Idaho, with just 32,515 residents over the age of 18. In addition, 66%, or 21,598, of the county's jury-eligible population reside in Moscow, the community most impacted by these murders. Didn't they say 25,000 people earlier? I mean, I know they did. Anyway, several rumors have proliferated in Latah County. For example, survey respondents reported that Kohberger had a bad history with women, was responsible for other murders in Pennsylvania and Washington, bragged about committing the perfect murder, and was acting strange after the murders. Others reported that he was obsessed with one of the victims, had dated her, tracked her location at all times, and had been in the house in the past. Survey respondents also mentioned rumors about drugs, not dogs, drugs, other suspects involved, an online business that was sexual in nature, and parties at the victim's house. The survey data show that the media coverage has shifted the burden of proof to the defendant. Many Latah County prospective jurors exposed to the prejudicial media coverage hold a presumption of guilt. About 67% of survey respondents who knew about the case reported that Bryan Kohberger is guilty of murder, with 25% indicating that he is definitely guilty. The presumption of guilt increased to 81% for those who recognized 7 or more media items. In addition, 51% of survey respondents reported that Kohberger would have a difficult time convincing them that he is not guilty of murder. Yeah, again, this is another strong point. I would add this to the list. This is number 3 for me. The point here about 51% of the respondents this is a clear burden shift here, right? That he would have a difficult time convincing him he's not guilty. That is a good one for them, right? Like in terms of, now the question is just going to be, is it going to be better elsewhere, right? But they're arguing it would be, which increased to 66% for those who recognized 7 or more media items. Just 19% reported that Kohberger would not have a difficult time convincing them of his innocence. As for sentence, 52% of survey respondents believe the jury should sentence Kohberger to death if he's convicted, compared to 24% who favor life without the possibility of parole. I mean, that's an interesting number as well for a state that is so frequently, that we have seen even, is seeking the death penalty for these cases. You would think that they would want that number to be higher, right? If they're going for the death penalty, considering all of the so many reasons we're not going to go into, but so many reasons not to do it. Like, I don't know. I would think that if you're going to be, it's so much more expensive. And again, I said I was going to go into it, but, so much more expensive and it's harder to convict, it's harder to get a jury. Those are just 3 of the many reasons. But I would think that number, 52%, doesn't really warrant it. The survey data also provide insight into the extent of personal connections among Latah County residents to Moscow, the University of Idaho, and these murders. Approximately 88% of those familiar with the case have talked about it or heard others talking about it in person or online. In addition, 78% of survey respondents lived in Moscow or knew someone who lived there at the time of the murders. Another 25% reported that they or a family member was a student or employee at the University of Idaho in Moscow. I'm surprised that number is not higher. A sizable percentage of the prospective jury pool was also connected to the murder investigation. Wow. Approximately 22% of Latah County survey respondents are employed or know someone employed by a law enforcement agency involved in the investigation. That's another problem. I would say that is like number 4 for me in my list now. Latah County residents lived in a perpetual state of fear during the search for the killer. Many survey respondents reported that they started locking their doors for the first time, and parents feared for their children's lives. More than half, 56%, of survey respondents reported that they or someone they knew experienced higher levels of stress, anxiety, or fear during the manhunt. That number increased to 63% for Moscow residents. The comparison surveys also found significant case recognition and bias across alternate venues. I almost said Venuses. Approximately 90% of Canyon County and 84% of Bannock County survey respondents were familiar with the case. The prejudgment rate in Canyon and Bannock counties were also high. 69% of Canyon County and 76% of Bannock County residents familiar with the case reported that the defendant was guilty of murder. Ada County is the largest county in Idaho with 406,068 residents over the age of 18. Its population is more than 12 times the size of Latah County. Approximately 93% of Ada County survey respondents have read, seen, or heard about this case, and 68% believe Kohberger is guilty of murder. However, there were important differences between the Latah and Ada County jury pools. Interesting. Ada County residents are far less invested in this case than their Latah County counterparts. Only 15% reported that they followed the case, quote, very, end quote, closely, compared to 29% of prospective jurors in Latah County. They were also less familiar with the prejudicial media items. Approximately 63% had read, seen, or heard that police found a knife sheath. Wow, that is shocking. Let me say that again. They're referencing here in Ada County. Only approximately 63% of those surveyed had read, seen, or heard that police had found a knife sheath on one of the victims' beds compared to 81%. I'm surprised it's not 100% everywhere. That's just me. Approximately to 81% in Latah County. 52% had heard that DNA on the knife sheath matched the defendant, which is 15 percentage points lower than their counterparts in Latah County. Ada County survey respondents were also less familiar with prejudicial misinformation, widely reported in the coverage and disseminated via social media. For example, just 35% had heard that the defendant allegedly followed one of the victims on social media. Ada County residents also had fewer personal connections to the case. Well, that makes a lot of sense. Only 20% lived or knew someone who lived in Moscow at the time of the murders. Just 4% reported that they or a family member was a student or employee at the University of Idaho in Moscow. In addition, only 2% of Ada County survey respondents are employed or know someone employed by a law enforcement agency involved in the investigation. That was my 4th big takeaway, was how many, where was it? I think it was 22%? Yep, 22% in Latah were employed or know someone employed by a law enforcement agency connected to the investigation, versus 2%. Ada County community members did not suffer severe levels of emotional distress during the search for the killer. Only 31% of prospective jurors reported that they or someone they know experienced higher levels of stress, anxiety, or fear during the manhunt, 25 percentage points lower than in Latah County. In conclusion, given the extent and nature of the pretrial publicity in Latah County, coupled with its negative impact on the jury pool, it is my opinion that there is reasonable likelihood that the defendant's constitutional rights to a fair trial have been undermined. As such, it is my opinion that remedial measures, including a change of venue, are appropriate to ensure a fair and impartial trial. Including, does that mean he thinks there's other measures that should be taken in addition? And if so, what are they? We'll never know, probably. Qualifications, education, and experience. A copy of my curriculum vitae can be found in Appendix A to this declaration. I'm not going to read all of this. I believe we heard him testify to this actually at the spicy hearing, as it's now dubbed by me as of today. Okay, the influence of attitudes on cognition. There is a substantial body of literature documenting the impact of attitudes on information processing. Attitudes have been shown to have an impact on selective attention, the evaluation of new information, memory recall, and behavior. This research provides insight into how media coverage may lead to juror bias. Pretrial publicity can have a prejudicial effect on jurors through its impact of the formation of attitudes and beliefs that they bring into the courtroom, obviously. Attitudes are not isolated entities, but are often linked to other memories, experiences, attitudes, and beliefs. Attitudes are linked to other attitudes. I don't know. It's kind of redundant. I hope I don't sound like I'm being super critical. I'm pointing out things that are just, to me, are just like, they should have been caught during the proofreading session if there was one. These links can create large networks of attitudes. Why is the word attitude, dude? What? Okay, hold on. I'm going to finish reading it and then we're going to count. Okay. These links can create large networks of attitudes which are resistant to change. The links between attitudes strengthen with repeated activation. As these links strengthen, the probability increases that the attitudes and underlying beliefs will be consistent with one another and brought to awareness simultaneously. Attitudes that are strongly linked to one another are more easily accessible in memory and more likely to be automatically activated with exposure to the attitude object. Attitudes can be activated automatically without any conscious, intentional processing. This is more likely to occur when an attitude has been repeatedly activated in the past. In this one paragraph, the word attitude is used 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. I might have missed one, at least 11 times. There's a lot of other words that could have been used, synonymous to the word attitude. Sorry, now my brain's going to pledge versus donate. Synonymous to the word attitude, right? Perspective, opinion, point of view, mindset, belief. I mean, the list would go on and on. Feel free to pop more synonyms for the word attitude or attitudes in the comment section of this video if you feel so inclined. When media coverage surrounding a case is broad, extensive, and redundant, speaking of redundant, strong links between relevant attitudes and beliefs begin to form. I'm going to have an attitude about this page 161 of this document here. If the pretrial publicity creates links between case details, attitudes, and beliefs over the course of a trial, these attitudes are likely to be automatically activated at a subconscious level. As described below, this network of linked attitudes can have an impact on a juror's attention and evaluation of the evidence and arguments presented in court. As the network of linked attitudes grows and strengthens, honestly, it's just so distracting. I don't even know what he's saying anymore. Specific attitudes, fucking hell, man, become resistant to change because change requires revisions to other attitudes. Holy fuck. Guys, what is happening? Other attitudes and beliefs within the network. Resistance to revising well-established attitudes has been shown to lead to biased information processing. When attitudes are strong, yeah, I'm now biased against this part. What is this called? Roman numeral 3, this section, I am now biased and have a negative attitude towards this section. Resistance to revising well-established attitudes has been shown to lead to biased information processing. When attitudes are strong, there is a tendency to favor arguments and information in support of those attitudes over arguments that may disprove them. The acceptance of a counter-argument can create cognitive dissonance. In an effort to avoid cognitive dissonance, information that supports attitudes may be selectively attended to and counter-arguments may be distorted or dismissed. Yeah, that makes sense. Attitudes can also have an impact on attention and recall. Research has shown that information that supports a pre-existing attitude is easier to learn, more accurately retained, and easier to recall. And I remember him mentioning that again in the spicy hearing. The links formed between attitudinally supporting... Jesus fucking Christ. Why? Just why? attitudinally supporting information and pre-existing attitudes are stronger than those formed between counter-arguments and pre-existing attitudes. I'm going to lose my fucking mind. As a result, the latter is more difficult to retrieve from memory. Further, there is a tendency to produce new beliefs which support pre-existing attitudes and suppress those that run counter to such attitudes. Okay, for the rest of this section, or for however long he continues to use the word attitudes like multiple times a sentence, I'm going to do this. You can follow along with my cursor so you can see what I'm reading. I'm going to start replacing the word attitudes with one of the many synonyms, just so I don't lose my mind. In sum, when a venue is exposed to prejudicial media coverage surrounding a crime, there's a risk that potential jurors will develop a large network of linked perspectives and beliefs relating to the victim, the defendant, and the crime. These linked beliefs include opinions about the guilt of the defendant, appropriate sentence, and evaluations of the evidence presented through the media. When the links between perspectives are strong, they can be activated at a subconscious level and have an impact on the jurors' evaluation of the evidence and arguments presented at trial. Positionally supporting arguments will be more closely attended to, evaluated as persuasive, integrated into the existing network of opinions and beliefs, and made easily accessible during deliberations. In contrast, counter-arguments and evidence conflicting with well-established points of view may create cognitive dissonance. As a result, jurors will either ignore this evidence or make cognitive efforts to refute it. This evidence will not establish strong links to pre-existing notions and will not be easily accessible during deliberations. When a venue has been saturated with pretrial publicity, these psychological processes can put the defendant at a significant disadvantage, undermine the presumption of innocence, and diminish the prosecution's burden of proof. The prejudicial impact of pre-existing points of view is accentuated by the fact that the media coverage underlying them is often biased in favor of the prosecution. Furthermore, news content is encoded under very different circumstances from those found in the courtroom because the rules of evidence that are strictly enforced at trial do not apply. As such, the persuasive impact of information presented through the news media becomes more significant and ingrained in the juror's mind than the evidence presented at trial. So let's look at these footnotes here. He's going to define cognitive dissonance for us. Cognitive dissonance is an uncomfortable feeling caused by holding two contradictory ideas simultaneously. People have a motivational drive to reduce dissonance by changing their attitudes, beliefs, and behaviors, or by justifying or rationalizing them. I decided I would allow it here because it's a footnote. For example, this is footnote 7. For example, people list more counter-arguments for information that refutes pre-existing attitudes than information that supports them. Okay, I can't. I'm going to keep scrolling to the next part where we left off. Roman numeral 4, the prejudicial impact of pretrial publicity. That is a lot of P's. There's a body of research within the social sciences that attempts to address the impact of pretrial publicity on decision-making in the courtroom. This literature suggests that pretrial publicity influences evaluations of the defendant, perceptions of criminality, sympathy toward the defendant, pretrial judgments regarding guilt, and final verdicts. These folks here conducted a field study that incorporated real-time evidence into the methodology. Participants included jury-eligible community members who were naturally exposed to pretrial publicity over a 14-month period leading up to the trial. Trial summaries were presented online during 6 sessions over the course of 10 weeks. The researchers reported a pretrial publicity effect that persisted throughout the actual trial. Despite the admonitions to set aside prejudicial pretrial publicity, oh my god, so many P's. Dude, another one. Hold on. 4 P's in a row. Despite the admonitions to set aside prejudicial pretrial publicity, participants were biased by the content of the pretrial publicity. I can say for a fact that while it's unlikely that anything in this document was proofread, I can say definitively that at the very least, this declaration of Dr. Edelman was never read out loud. Because something would have been changed, because that is not natural to say. If it's really hard to say, it's not going to be as natural to read it either, I would say. Specifically, those exposed to prosecution-oriented articles were more punitive in their guilty ratings across all 6 sessions compared to those exposed to pro-defense pretrial publicity. The amount of the pretrial publicity participants, why though, were exposed to also had a The amount of pretrial publicity participants were exposed to also had see what I mean? It's distracting. Also had a significant effect. In addition, the biasing effect of pretrial publicity did not disappear. That's a lot of that's a lot of authors. did not disappear over time. Thus, neither delay nor trial evidence eliminated the pretrial publicity effect on judgments of guilt. Let's see if there's anything else new and interesting. All right, media analysis. This is Roman numeral 5. An effort was made to collect articles published in newspapers with circulation in Latah County to assess the extent of coverage surrounding this case. A search of the Moscow Pullman Daily News, Idaho Argonaut, and the Lewiston Morning Tribune uncovered 444 articles which reference these events between November 13th, look at that, he got the year right, 2022, and June 23rd, 2024. This is a conservative estimate and does not include other newspapers with readership in Latah County. The nature of the pretrial publicity is an important factor to consider when weighing the need for a change of venue. The initial pretrial publicity chronicled the elevated state of panic and fear in the community as residents and university students anxiously waited for law enforcement to announce an arrest during the search for a suspect. With the public demanding answers, the media drew on information from the 5 press conferences held by the Moscow Police Department, 8 interviews with Chief Fry and Captain Lanier, and almost daily press releases, which we already scrolled through a bazillion of. This culminated with the widely televised press conference held by Chief Fry and County Prosecutor Bill Thompson. Again, he's referencing this for the millionth time, after the December 30th arrest. Examples of this type of reporting include: he asked the public to remain vigilant as the killer is still on the loose. We cannot say there is no threat to the community, and as we have stated, please stay vigilant, report any suspicious activity, and be aware of your surroundings at all times. Well, having said that, law enforcement will always say this to everyone, no matter where they are, and whatever. They're always going to say, anywhere. Like, where I live today, they're going to say, yep, be vigilant, report suspicious activity, be aware of your surroundings. Now, I'm absolutely oblivious to my surroundings, but still. Fry also addressed frustrations from the public over the slow pace of information coming from his department since Sunday. Fry said police are looking at all evidence, including social media and anyone who might have a connection to the case. Obviously, though, I don't understand. Fry offered assurance that the police are doing everything they can to let the people in our community know that we care. I don't understand. What is this supposed to be representative of? These are examples of the type of reporting. I don't get it. I mean, you want your law enforcement to care, right? We want them to feel safe, he said. We want them to be safe, and we're going to do everything we can to do that. I mean, none of these are anything specific towards Kohberger, first of all. These are just, a lot of this could be true just generally speaking, like I said, anywhere. UI Dean of Students, Blaine Eccles, said the university has increased campus safety patrols and students can arrange a security escort across campus. Again, that could be true regardless of whatever the suspect ends up being, right? We heard about the candlelight vigil. So some of this is kind of, repetitive. The perpetrator acted with stealth. They have no suspect in custody. They have no murder weapon. I don't know if this is proving what they hope it's proving. To me, this has the opposite effect. A killer who committed a mass murder in such a fashion and then escaped detention heaped rarity upon rarity. That's just a weird sentence. There's no imminent threat to the community at large. I mean, I don't understand the point of this. There is no suspects and many questions are still unanswered. Police are trying to piece together what happened. Okay. During the 7-week search for the killer, law enforcement was hesitant to release information to the public that could undermine the investigation. This left an information vacuum, which allowed misinformation and rumors to flourish. Yes, that's factually true. Yes, absolutely. Videos of purported suspects appeared on social media, and a so-called, the TikTok psychic internet sleuth made false accusations against a university professor. Groups were created to discuss the murders and share information, blah, blah. This is beginning to feel a bit like they made their best points a long time ago, and I don't know that this is necessary. All right, during a December 30th, 2022 press conference, which was live streamed on YouTube, Chief of Police James Fry, and this is the guy who's running for sheriff, apparently, and Latah County Prosecutor Bill Thompson announced that Bryan Kohberger had been arrested. Although few details were released, Mr. Thompson pointed the media to the probable cause affidavit. Yeah, trying to shut all this shit down, right? As in the prior shit that was just listed. Which would be released after Kohberger's extradition from Pennsylvania. With the court issuing a gag order in an attempt to protect the defendant's due process rights, the media drew heavily from this document and widely reporting on purported evidence connecting Bryan Kohberger to these murders. For example, the DNA, cell tower data. These details were widely disseminated and discussed by the media for 16 months without any debate over their veracity. That's just not true. That's factually not true. There's been plenty of debate over the veracity. Tons of it, actually. Only during an April 2024 hearing regarding the defense's change of venue survey did Mr. Thompson state in open court that many of these, quote, representations, end quote, which were tested in the survey, were false or may not be offered at trial. Despite the court's best efforts to stem the flow of prejudicial information to the public, Latah County residents have been saturated with a deluge of details pulled from the affidavit, warrants, and other documents that were not filed under seal. Much of this coverage has the potential to undermine the presumption of innocence and shift the burden of proof onto the defendant. The media detailed evidence allegedly linking Kohberger to the murders, including cell tower data, tracking his movements, video footage of the purported killer's car near the victim's home, an alleged DNA match with more than a 99... Look at the quotation being backwards. I'm going to lose my mind. Again. Like, what? Why? How? Dude, what? How? If you were in middle school and you submitted an essay and you put your quotations in backwards, you would lose points. Just saying. More than a 99.9% likelihood of connecting Kohberger to the crime scene, evidence confiscated from Kohberger's home and car, and eyewitness accounts from one of the victim's roommates. Examples of this type of prejudicial coverage include... more of this. I cannot. We know what this is. It's just, This is the document that never ends. It just goes on and on, my friends. Okay. The coverage also focused on Bryan Kohberger's alibi, which was called into question in the coverage. On August 4th, 2023, it was reported that Kohberger claimed to be, quote, on a late drive, end quote. Look, he got those quotes correct. Around the time of the murders. According to the Publicity, he had and now it's backwards again. Oh my God. He had a habit of going for drives alone, but had not yet developed any evidence to support his alibi. The media often drew on comments in the prosecutor's filings attacking the alibi, which was described as vague. We got quotes working in the right direction again now. And lacking supporting evidence. This criticism was left uncontested until April 17, 2024. Examples of this type of reporting include, and more examples, we know all this. The Latah County community has come together in support of the victims and their families. For example, there were several candlelight... Oh my God, the candlelight vigils again? Really? Really? Dude. Okay. Again with the healing garden, dude. The media has also kept this case in the public's consciousness by providing constant updates on court proceedings, no matter how trivial. These hearings have covered a... Dude, okay. They're public, right? They're public. I'm going to keep reading before I have a whole, rant. These hearings have covered a range of topics from the court-imposed gag order to evidentiary disputes. As part of the coverage, the victims' families and the public have been critical of perceived efforts by the defense to delay the trial. There was also significant coverage surrounding the defense's change of venue survey, which came to light after the government filed an unsealed motion to stop the data collection process. This resulted in another deluge of prejudicial coverage and discussion on social media and YouTube after 2 hearings were streamed on court TV and watched by thousands. The media drew, and that's the spicy hearing that I'm like, man, I wish I'd covered it, but I decided to start, that was the turning point for me, as I said at the beginning of this video. The media drew on the prosecution's court filing and arguments during the live-streamed proceedings, accusing the defense of spreading misinformation and tainting the jury pool. This coverage fed the public perception that the defense was trying to undermine the judicial process or get Kohberger off on a legal technicality and further undermine the court's efforts to stem the flow of information to prospective jurors. Examples of this media coverage include... these are just quotes of Bill Thompson. These are just quotes of him from the hearing. And it's funny because they had a lot of back and forth, and this is very clearly, dude, he's taken a lot of shots at Bill Thompson. This is entertaining in a way, but I'm not going to read all of it because this is really long. This whole thing is long. That's what she said. In conclusion, oh, thank God, my review of the pretrial publicity indicates that the Latah County jury pool has been saturated with prejudicial coverage surrounding the sensational murders of 4 University of Idaho students, the ensuing search for the killer, public statements from the victims, family members, and evidentiary details from after Bryan Kohberger's arrest. The media reported extensively on alleged evidence, some of which proved to be false or misleading. These killings sent shockwaves through the local community and generated a state of panic. Between 25% and 40% of the student body failed to return to Moscow after the Thanksgiving break. Before the defendant's arrest, there was widespread frustration with the lack of details made public about the ongoing investigation. Oh my God, why is it not ending? Why is there more? As I scroll down, there's more. With minimal official information available, rumors, speculation, and misinformation proliferated. The survey data include that the media coverage has negatively impacted the Latah County jury pool. For example, oh my God. He's already said all this. This is, dude, I'm not going to read this. He's repeating what he already said. He's literally repeating it. Okay, we're going to move along. Okay, let's just see. It is my opinion that the results of the telephone survey indicate that there is bias in the Latah County jury pool against the defendant stemming from exposure. Okay, at this juncture, I don't know why this is happening because he's already given us all of these. Literally, he's just copied and pasted this. What? I remember reading this and pointing this out, the 51%. And this is the much better way to do it. Let's just have a nice chart. Here we go. On the left, these statements, they're questions. If they've heard, see, it says, have you read, seen, or heard if. There's no column for if they have or haven't, like yes or no. So he's actually is not explaining it. So I guess we are supposed to assume that everybody answered yes to these. Okay, and then the only thing at issue here is how many believe the defendant is guilty and how many would actually have a difficult time convincing that he's not guilty. So burden shifting. Okay, I'm going to try to make sense of this. So let's just say, so essentially, this is the same group, right, being asked both questions, right? And so after, well, the first question, we're assuming everybody said yes, they've heard of it. So then, like the 62%, I can only fathom that that's of the 81, right? Like, first of all, they would say, okay, do you believe he's guilty? And they would say yes. I guess 81% say yes. And then they would follow that up with, would you have a difficult time believing that he's not guilty? And of that 81%, 62% said yes. If that makes sense. That's how this looks to me. Okay, so Bryan Kohberger stalked one of the victims. 81% believe he's guilty. The other way to look at this is that 19% believed he wasn't. But then 62% of that 81, defendant would have a difficult time convincing them not guilty. Okay, Bryan Kohberger said that he was out driving alone on the night of the murders. 79%. Actually, these are like exactly the same. So for the next question, Bryan Kohberger had followed one of the victims' social media, same exact percentage as the previous question. DNA found on the knife sheath was later matched to Bryan Kohberger. Interesting to me that it's a lower percentage that believe he's guilty. Wow. The stalking is the highest percentage. Huh. That's interesting. The stalking... Okay. Like, dude, okay, never mind the stalking. The idea that he was out driving alone the night of the murders, a higher percentage of people think that means he's guilty versus that the DNA matches the knife sheath. How? I mean, yeah, it's only 4%, but still, I don't know. Y'all, okay. So, for the knife sheath and the DNA, 75% believe guilty, and then of that 75%, 60% would have a hard time being convinced not otherwise. Next question. University students in Moscow and their parents lived in fear until Bryan Kohberger was arrested for the murders. That's a stupid question, in my opinion. 74% and then 56%. I think at this point you guys know what they're relating to, so I'm not going to keep reading each thing. I'll just say the numbers. Police found a knife sheath on the bed next to one of the victims. That's 72% and then 55%. Bryan Kohberger owns the same type of car recorded on the video driving in the neighborhood where the killings occurred. That's, again, 72% and 50%. You know, again, this to me seems like that should be higher up. Like, that seems like that should be higher up versus just him driving alone, right? This is, you guys, what? I don't understand. Dude, and the one at the very bottom rung, actually, the last three are tied. So the knife sheath next to the victims, owning the same car, and then the cell phone tower data shows that he made several trips near the victim's home in the months before the killings. All three of those have the exact same percentages, which is 72 and then 55. Okay, I can't explain. I'm just going to keep reading. Consistent with what often happens in smaller venues, rumors, conjecture, and misinformation have spread through informal discussion and alternate communication networks such as social media. Approximately 88% of Latah Latah County survey respondents who recognize the case have talked about the murders or heard others talking about them in person or online. Okay, this is again just more of the same with these percentages. These are all rumors and conjecture, so I'm not going to read these. We've all heard them before. Impact on the community. This crime had a devastating impact on Latah County residents, many of whom consider this to be a very safe and close-knit community. Dude, we know it's close-knit. Like, we've heard all about that already. Prior to the murders, oh my god, again with the, dude, are y'all seeing the redundancy in this? This is kind of mind-boggling. The whole thing with the anxiety and the fear and stress. I mean, I read this a couple times before it was mentioned an additional many times. And at that point, I was like, oh, I guess at that point, I was like, oh, I'm recognizing there's a lot of redundancy. I can just skip certain things. But, like, I actually, dude, wow. Like, you don't expect that, right? You expect it to be the same words, but something different. But it's the same. I just don't even know. Again, with the Thanksgiving break, for the millionth time, you guys, I'm going to lose it. Okay. He's got to be wrapping up soon, right? He's already repeated everything a bunch of times. Community pressure. Okay, this is new. Thank God. These comments reinforce the quantitative data which show a strong presumption of guilt in Latah County. Examples of these types of reactions to a hypothetical acquittal include: they'd burn the courthouse down. Outrage would be a mild description. Very upset. They would think the jury failed. I think we would all be heartbroken all over again, and fear would probably rise in us again. I don't think we would be okay with a not guilty verdict at all. It would be very hard for our community to accept, and it would be difficult for us to move forward and feel safe in our own community like we once did before this horrible tragedy. Oh my gosh, I would be so afraid. Possible riots. We will be disgusted unless some major of evidence proves different. Well, that's an open mind. Kind of. I mean, they flipped it, right? Like a presumption of guilt unless they can prove he's innocent. So it's flipped, but at least it does leave room for the possibility. The entire county mostly believes he's guilty. That doesn't mean anything. I mean, people can believe whatever they fucking want. They better have substantial evidence to not convict. And people will be fine if that was the case. Okay, again, it's still better than some of the other statements. If he's not guilty, prove it. Again, that's flipped. And now I'm like, that's why they're including these, right? Because it's burden shifting. Yeah. They will have to prove with real evidence that he's not involved in the murder. To prove. This pisses me off, actually. I can't stand this shit. I can't imagine that happening because they have so much against him. We would be dumbfounded. I don't see how. I cannot imagine this. Okay. Those are just normal things. It's the burden shifting that really, is a shame, especially. I think the general consensus is that he's guilty. What? You guys, I think the general consensus is that he's guilty. Well, lock him up, boys. What? Have they never heard of a trial? Have they never heard of a jury? Oh my God. What? Okay. This speaks to me that we need to do, somebody, I don't know who, I think it's clear that the citizens of this country in general could do with maybe being a little bit better informed about the justice system. I'll leave it at that. I think they would be angry and shocked. I think they should try him right here, right where you're standing. Like, what do you mean? Most people are convinced he's guilty. I think everyone pretty much decided it was him. Oh my God, I'm gonna lose my mind. Riots, parents will take care of him. Mother of God. People may or may not take things into their own hands. Well, we don't want that. Oh my God. Someone would do the good old boy justice. Well, so if he's acquitted, he's definitely not safe. That's clear. He'd have to join like the witness protection program or something. I'm not going to continue reading these because it's a lot. Comparison surveys. Again? Wait a second. Again with Bannock County. Y'all. It's like that movie Groundhog Day. I'm at a loss for words. Okay, new section. Section 7. Ability to select a fair and impartial jury in venues saturated with media coverage. Haven't we also done this already? Okay, this, thank God, we've got something from case law. I'll read this. The Supreme Court has recognized the limitations of the voir dire process as a remedy where potentially prejudicial pretrial publicity, not the 4 Ps, dude, is an issue. In Irvin versus Dowd, the court concluded, no doubt each juror was sincere when he said that he would be fair and impartial to petitioner, but the psychological impact requiring such a declaration before one's fellows is often its father. Oh, this is the Luke where it's I'm your father thing. Okay, never mind. We already read this. Research on voir dire shows that these concerns are justified. Jurors are often reluctant to disclose relevant experiences, relationships, or opinions that may lead to bias even when pretrial publicity is not an issue. One study found that while 71% of jurors had a fixed opinion regarding guilt, only 15% admitted so during voir dire. I mean, I believe that. I believe it. Yep. Seltzer, my favorite type of water. Sparkle. The water that sparkles. Oh, that could be a slogan for a seltzer company. Seltzer. It's the water that sparkles. I was going to say I'd buy it, but I already do. So, those of you guys who don't already drink sparkle water, what do you think? Are you like, man, I'm going to give that a try? Oh man, this is what this is doing to my brain. Okay, this is interesting. High-profile cases also create a unique challenge during jury selection known as the minimization effect. And there's a footnote here. It's from this book from 1989. This concept refers to the prospective jurors' attempts to minimize the full extent of their exposure to pretrial publicity. And I believe, again, he mentioned this at the ye old spicy hearing. During voir dire, prospective jurors try to downplay their knowledge of the case using qualifiers such as just, nothing other than, only, a little bit, and that's all. In an archival study that analyzed the jury selection transcripts from 5 high-profile cases, 69% of prospective jurors use minimization language when questioned by the judge or attorneys. Another challenge in cases with significant media coverage surrounds the difficulty jurors having during voir dire to recall every detail they have read, seen, or heard about a case. And we heard about that at length from him during that hearing. These types of open-ended recall questions require significant cognitive effort and often result in incomplete recollection. This phenomenon is an inherent limitation in how memory works. For example, if someone is asked to recall everything they know about the movie Star Wars, you've got to be kidding me. You've got to be kidding me. That's weird. That's weird, because I've already mentioned Star Wars twice. Their description would likely miss important details they are familiar with. Memory is much more accurate when answering recognition questions. He means leading. Have you read, seen, or heard if Darth Vader was Luke Skywalker's father? So, y'all, some of you guys might already know. I've never seen Star Wars, but, I know this. I knew it enough to even make, so far, 2 Star Wars references earlier regarding the father thing. So, having never seen the movie. So, another obstacle is the well-documented tendency for individuals to respond in a manner that will be viewed favorably by others, which has been coined the social desirability effect. It could also be called wanting to be cool or something, right? This phenomenon has been researched and found in a multitude of disciplinary settings, including the courtroom. Socially desirable responses are more likely to occur when individuals become focused on the public aspects of themselves. Public awareness of oneself can become particularly salient in a courtroom setting where prospective jurors are asked questions by an authority figure in front of a public audience. Yep, now that makes sense. Also referred to as response bias and demand characteristics, this effect causes the juror, or the interviewee, to pick up the subtle and overt clues as to what a lawyer or judge wants to hear. During voir dire, a clear, strong message is often sent to prospective jurors. Good jurors are not supposed to have prejudicial information or biases about the case. I don't agree with that, because neither side wants biased jurors. And neither side is going to say, oh, you're a good juror if you answer this way or that way. If they do, then they should set them aside and decide the case solely on the law. Now, that's true. This is true, that they should. They tell that to everybody. But it's because they say, well, everybody has biases. They're not saying you're a good juror or a bad juror. They're saying everybody has biases, and you have to set that aside and decide on the law and the evidence presented in court. Anyway. When this is established, many prospective jurors will adjust their public statements to meet those courtroom norms. Well, I get what he's saying, but at the same time, I don't think you'll find a psychologist anywhere who would say that any human on the planet is without bias of some sort. It's like everybody has bias, even if it's implicit bias, right? We're born with it. You know what I mean? So it's really well, I get what he's saying. There's no way to not have this happen unless you just have robots. Although I would say, it's a good question. Can AI get bias? Learn bias? I would imagine they could, right? How could they not, right? If they're learning, that's a whole other squirrel hole. We're not going to go down that squirrel hole right now. So is he faking us out again? Because, y'all, how many times has he already said, in my conclusion, it's my conclusion to conclude? Like, I feel like he's, like, trying to trick everybody. Is this really your conclusion, or is this another fake out? Roman numeral 7, conclusion. It is my, I bet we could probably write this, like, if I were to, like, if we were to redact this, and then we were to try to write what we think his conclusion is, we could probably all get pretty close at this point, having seen a lot of the same stuff over and over again. It is my opinion that the residents in Latah County have been exposed to extensive prejudicial pretrial publicity and social media. Oh my God, do I even need to read all this, y'all? This is all the same shit, though. How is he not just concluding? He's just repeating and regurgitating. The conclusion should have been, dude, 3 or 4 sentences, done. The more you repeat it, it just waters it down, man. Dr. Edelman, I know you know what you're doing when it comes to the freaking surveys, but you know what? I hate to say it. There's room for improvement when it comes to writing your declarations. That's what else. And then, icing on top, in conclusion. Not to mention, it's redundant because it's in Roman numeral 7, which is called conclusion. Oh my God. I'll read this. This is what I was expecting. He could have just skipped all this and just gone straight to here. In conclusion, given the nature of the pretrial publicity, its negative impact on the Latah County jury pool, and the small size of the county, I believe there is reasonable likelihood that the presumption of innocence has been undermined and shifted to a presumption of guilt. Yes, this is what you needed. This is all you do. Didn't need to repeat everything again. As such, remedial measures are necessary to protect the defendant's constitutional rights to a fair trial. A fair and impartial trial. Based on these findings, it is my opinion that a change of venue would be an appropriate prophylactic measure to mitigate the prejudicial impact of pretrial publicity surrounding this case. And if there weren't enough P's already, he had to throw another one in with prophylactic. I'm going to say another P that would be helpful is proofreading. I declare under the penalty of perjury, blah, blah. Oh my God. Okay, he's done. He's done. So what is after this? His curriculum vitae. I don't even care anymore. Dude, he got the year wrong of that big, huge press conference, the one he's all up in arms about. Got the year wrong. Backwards quote. Dude, the Kohberger. Okay, now here is the survey instrument. That's interesting. Hello, my name is... Should I do it in a funny voice? Hello, my name is Roberta, calling from the National Survey Company. We are not selling anything, and this is not a political poll. We're doing a public opinion survey among local residents to obtain opinions about an upcoming jury trial. Your cooperation is very important because your household was selected at random by computer as being representative of your county. Again, we're not selling anything, and this is not a political poll. How many people you think are hung up by now? If the respondent hesitates to cooperate, say, if you like, you can verify the authenticity of the survey by calling Maximilian at National Survey Company during regular office hours. Call collect 1888 Roberta. Oh my God. It says do not read. Y'all. What if they accidentally read it? Does the respondent have a reasonable working knowledge of English? Press 1 for yes, press 2 for no. Oh my God. First, do you live in Latah? Oh my God, look, it gives them how to pronounce it. And what do you know? Only 1 quotation mark. At least it's not backwards. 1, yes. 2, no. Discontinue survey. 9, refused. Discontinue survey. Have I reached you on your cell phone or landline? I don't know why that matters. Are you a U.S. citizen? Blah, 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 blah. And again, coaching them how to say Latah. Look at this. Every time, it's missing a quotation at the end. They copied and pasted it. It was incorrect, and then they just copied and pasted it. Okay. Main questionnaire, Latah County. All right, let's take a look at this questionnaire. Before I begin asking questions, I'd like you to know that there are no right or wrong answers. You mean no good juror, bad juror? And that you are free to respond with, I don't know, or no opinion answer to any question. All of your answers will remain confidential! Exclamation point. Yay, confidential! Question 1. Now I'd like to read you a few statements about the criminal justice system. Please tell me whether you strongly agree, somewhat agree, somewhat disagree, or strongly disagree with the following statement. Question 1. Question 1A. If the government brings someone to trial, that person is probably guilty. As you can see, they can answer the options there. Strongly agree, somewhat disagree, strongly disagree, no opinion, don't know, or refused. Okay, so next question, question 1B. Next, it is better for society to let some guilty people go free than to risk convicting an innocent person. I would not know how to answer that, and here's why. Because no one can be guilty if they haven't been to trial yet. So I don't understand. Like, this question doesn't make sense logically. Like, how you can't determine if someone's guilty or innocent if there hasn't been a trial. So that doesn't make any sense. I would refuse to answer. Last one. Question 1C. Last one. Even the worst criminal should be considered for mercy. Mercy? See, these are weird, because to me, I'm like, mercy? Is that referring to sentencing? Like, that to me sounds like they've already been convicted, and then this is in reference to sentencing, right? Is that what I guess that would be it? Like, death penalty? These questions are tough if you're me. Okay. Now I'd like to ask you about an upcoming jury trial in Latah County. Back in 2022, 4 students attending the University of Idaho in Moscow were stabbed to death in their home. About a month later, Bryan Kohberger, and they gave them a little helpful hint on how to say that, was arrested and charged with murder. Have you read, seen, or heard anything about this case? Yes, no, don't know, refused. And then, look, it's got a little roadmap of what to do next. Bryan Kohberger was arrested at his parents' home in Pennsylvania. Have you read, seen, or heard anything about this case? Okay. Based on what you've read, seen, or heard about this case, do you believe Bryan Kohberger is definitely guilty, probably not guilty, or definitely not guilty of murder, and then blah, blah. The response options should be rotated for half the sample. That's a good idea. Given what you've read, seen, or heard about this case, would Bryan Kohberger have a difficult time convincing you that he is not guilty of murder? How closely have you followed this case? Would you say very closely, somewhat closely, not too closely, or not at all? What have you, and then here's the open-ended, what have you read, seen, or heard about this case? What rumors or theories, if any, have you heard about these murders or the victims? What are your thoughts and feelings about Bryan Kohberger, the victims, and this case? What 3 words do you believe best describe Bryan Kohberger? Suspect, innocent, custody. I'm thinking in custody. I guess that could count as one word because it's hyphenated. What is your opinion of Bryan Kohberger? Is it very positive, somewhat negative, or very negative? No opinion? Why am I answering it? No one cares what I think. How did these murders impact your community? The prosecution is seeking the death penalty for Bryan Kohberger. If the jury finds him guilty of first-degree murder, it must then decide on whether to sentence him to the death penalty or to life without possibility of parole. Which sentence do you believe the jury should select? How can they answer this, though? How? How can they answer this? They have not been presented with any mitigation evidence, and he hasn't been found guilty in the first place. Dude, I would have a hard time. I'd be like, y'all's survey's whack. That's what I would call it. I would say it's wackadoodle. You guys, go get a better survey. Come back. Call me when you have a better survey. Given what you have read, seen, or heard about this case, would Bryan Kohberger have a difficult time convincing you he should receive life without the possibility? These questions are fucked up. How do you believe residents in Ada County would react if the jury found Bryan Kohberger to be not guilt? I guess that's supposed to be guilty, but What concerns, if any, would you have about serving as a juror in this case? As you may know, the media has reported a number of things in this case. Okay, now we're getting to the more specific ones, right? So have you read, seen, or heard that the police found a knife sheath? Sorry, not a pocket, a knife sheath. Have you read, seen, or heard that the DNA was matched? We already saw these from the other chart things. Okay. Have you watched any episodes or shows covering the Moscow murders, for example, on Netflix, Paramount, or Dateline? You joined any groups about it? You listened to any true crime podcasts? Ask everyone, it says. How often do you read a hard copy or online version of a newspaper? And then now it has the different publications. Do you read any other newspapers? Instruction. Do not read the list of newspapers to the respondents. Why is it underneath the list then? Tell me that. Somebody answer me. Why is that underneath the list? Okay. And let's look at this. So here's some nice pie charts. Volume of media coverage. Latah versus the rest of Idaho. And then there's the population differential. Yeah. that's, I mean, it's not surprising, really, based on what we've already heard. And there's that. Media coverage, Ada. So, media coverage in Ada County is less versus the rest of Idaho, but the population is obviously a lot higher. So, yeah, I mean, dude, for me, it's a no-brainer. This should be held in Ada County. Honestly, it's a no-brainer. I have a lot of problems with this freaking document. It's wrought with error, obviously. It's a complete and utter disaster in a lot of ways. The concepts behind it are good, right? I'm not saying that it was flawed methodology or whatever. It's just the writing I mean, I'm sorry, but it's atrocious. It was atrocious. It was atrocious. It was actually, I thought it was bad before it got to his declaration, back when it was just the actual memorandum, which was written by the defense team. But I take it back. That was nothing compared to this declaration. So, all right. I'm not trying to be mean. I'm really not trying to be mean. I'm just really surprised, right? But in other words, what I'm saying is like, the methodology I think is spot on. I think the point is spot on. Just the writing, though. Okay. And there were a couple things where I was like, yeah, I don't know if that really helps your case. But again, they'd already made, my thought is they already made their case, right? They could have chopped 100 pages off of this, stuck to the strongest points, especially the ones that hadn't been presented before. Don't repeat everything a bazillion times, right? Because it loses its effect. And then you also will lower the potentiality of typos. The less you type, the shorter it is, the less room for error. Anyway, okay, so you guys, hold on, stop everything. Now it gets interesting again. Okay, this is the curriculum vitae of James Murphy, who I don't even think was mentioned as, like, I don't think he's even going to be a witness or anything, or, an expert. I don't think he's involved in this trial at all. But here's his curriculum vitae. Here's what's so great. James Todd Murphy. Here we go. Personal interests, you guys. Enthusiastic collector of vinyl records. Enjoys traveling to network with industry colleagues and friends. Family-oriented, married to Stephanie Murphy with 2 adult children. Well, I hope he has a really nice life. That sounds lovely. You guys, can we just take a moment and give ourselves all a big round of applause? I know you can't see me, but I'm clapping in a circle because we only have 69 pages left to go. We're doing it. We're making our way through. Well done, everybody. Yay, team. Squirrel power. Yeah, squirrel power. Okay, so what are we looking at here? So just to remember why we're doing this. So this is going to be another witness that we are going to hear from on August the 29th in this motion to change venue. And this expert, Scott Sundby, was referenced also by Dr. Edelman. So now we have come upon Scott Sundby and his qualifications and what he is doing. Why are you here, Scott? Well, let us find out together. Okay. We see it's got some University of Miami School of Law letterhead, and I do appreciate that they took the care to redact his personal contact information. All right, I have been asked to address the potential effects on fairness when a high-profile capital murder case involving 4 victims from a small community is tried before a jury consisting of that community's citizens. I base my opinion on my research with the Capital Jury Project and other research into juror decision-making. Expert qualifications. I hold the Robert blah, blah, blah chair. Okay, so that's fancy. I've studied capital punishment law for 39 years as part of my scholarship and teaching responsibilities. I'm not going to read all this because we will hear him go over this, I'm sure, when he testifies at that hearing on August the 29th. So, okay, here we go. Let's see. I've been involved as a primary investigator with the Capital Jury Project since its inception in 1992. Ooh, inception. The CJP is an ongoing study originally funded by the National Science Foundation to determine how jurors in capital cases decide between life and death sentences. I have to say, I do think that's a very fascinating area of study. The CJP has conducted in-depth standardized interviews lasting on average 3 to 4 hours with approximately 1,200 jurors from 353 capital cases from 14 different states. Well, I was going to say, shouldn't they have done all 50, but not all 50 states have the death penalty, but still, I feel like they should do every state that has the death penalty, right? Of which roughly half served on juries that returned a life sentence and half served on juries that returned a sentence of death. I also was a principal investigator for a National Science Foundation funded project, judging capital murder cases. This project interviewed judges, judging capital murder cases, I get it, that's funny. This project interviewed judges who were the sole decision maker for deciding whether to impose a death sentence under their state statutes. Interesting. The study utilized the same methodology used for interviewing jurors. The project terminated with the Supreme Court's decision in Ring v. Arizona. I was going to say, I don't think any states have that option anymore. So, yeah, that's because this case law, this is U.S. Supreme Court case law, I'm sure, was the turning point for this decision has to come from the jurors and not from a judge. So that would be why that project terminated. Since its inception, CJP researchers have published over 50 articles and 2 books based on the data. I'm familiar with all of the published literature relating to the CJP data. I've written 1 book, A Life and Death Decision, A Jury Weighs the Death Penalty. And I have to say, I really appreciate here how he has cited this using the Blue Book Uniform System of Citation, which is the way that you are required to cite anything that you would use as a source for legal research and include it in a document, and you would need to cite it. You have to follow this Blue Book Uniform System of Citation, and the way that I can recognize that is because of the small caps, which you don't see very often. At least I don't see it very often. It's kind of specific to following that Blue Book Uniform System of Citation, so that's pretty cool to see. So I've written 1 book, 8 articles, and 3 book chapters using CJP data. To date, my work on the death penalty has been cited over 50 times by over 30 different courts, including twice in United States Supreme Court opinions, a Westlaw search. Ooh, I love Westlaw. Shout out to Westlaw. Search will also show that my publications have been utilized in a number of briefs and motions by both the prosecution and the defense. My writings have examined a variety of aspects of the death penalty decision, including jurors' use of mental health evidence, the role of the defendant's remorse in affecting the jury's decision, the impact of expert witnesses, the importance of how jurors perceive the victim, the process of jury deliberations, and how different trial strategies influence the jury's choice between a life and death sentence. Interesting. These, an interesting case for him to do would be Chad Daybell, because of how unusual it was that he waived, like at the when the verdict was read, right, they waived the right to poll the jurors, and then during the mitigation phase, they didn't really put on any evidence. I mean, they didn't bring in any experts. They didn't really try. It was really bizarre. Anyway, that would be a good one for him to study. These and other CJP studies have been cited in a number of judicial opinions. The findings on how trial strategy affects a juror's death penalty decision was relied upon by the United States Supreme Court in Florida versus Nixon. Although the CJP, I don't know why that is that like that. Okay. Although the CJP research is based on interviews with jurors outside of Idaho, the aspects of death penalty decision making I've written about apply to jurors in Idaho cases as well. The Supreme Court has so closely regulated the nature of the capital punishment decision, the manner in which jurors deliberate does not meaningfully vary between state statutes and schemes. Yeah, that makes sense. Okay, the effects of community pressures on jurors. In formulating my assessment, I've taken into account that Moscow and the surrounding county is a tight-knit... Wait a second. Did he have a little chit-chat with his buddy, Dr. Edelman? I mean, I don't know if they're buddies, but, I don't know, that's funny, because they... Interesting. We heard Dr. Edelman, or saw Dr. Edelman say tight-knit, I don't know, about 5,000 times. Community of approximately 41,000 residents, and that the 4 victims were students at the University of Idaho, the institution around which the town largely revolves, both economically and reputationally. I also am aware that the residents of Moscow suffered a great deal of understandable anxiety over the murders, and that many students did not return for the end of the semester following the murders because they did not feel safe. Two distinct dangers arise from holding a capital trial in a small community where the victims of the high-profile murders are local residents. The first is that jurors will be distinctly aware of community outrage, and as a result, some are likely to fear. So this has already been referenced by Dr. Edelman. This is like the societal pressure, right? We are very familiar with that from before. Crucially, because the death penalty is an individual moral judgment by the juror of whether the defendant deserves the death penalty, the pressure is heightened. A juror voting for life instead of death will know that their decision will be interpreted by the community, many of whom they are likely to know personally, as saying that the victims and community's sufferings were, quote, not worthy, end quote, of the death penalty. To base a death sentence on fear of community reaction would, of course, fall outside Idaho's statutory basis for imposing a death sentence and constitute, quote, arbitrary and capricious, end quote, punishment under the Eighth Amendment. Second, because the victims were students at the university, the institution which is the heartbeat of the city, the ripple effect of the murders makes potential jurors, in a very real sense, victims once removed. Unlike the isolated murder of a town resident, as tragic as that might be, these murders traumatized Moscow as a city, both emotionally and economically. Blah, blah. Just as we would not allow a guard who worked in the same prison to serve on a jury where a defendant was on trial for the murder of that prison guard, or of a prison guard, the distinct danger is that Moscow residents will not, no matter how hard they may try, have the objective emotional detachment required to serve as a capital juror. Again, I completely agree. I agree with this. I think they need to change venue. 100%. Again, it is essential to remember that capital jurors are required not simply to find facts, but to use their own individual moral assessment. I mean, he's spot on. He's spot on. It's interesting. I'll use that word. It's interesting that that's something that we ask, that the government asks of people in deciding the fate of someone's life, to make that decision based on their individual moral assessment. I just think it's interesting that happens. Individual moral assessment in deciding whether the defendant should live or die. Keep reading, Chelsea. The fair and impartial nature of that assessment is inescapably in question, where the jurors or individuals close to them have suffered psychological and, in some cases, economic harm from the defendant's alleged actions. It should be stressed this is in no way a criticism of the ability of Moscow residents to be fair and impartial in a typical murder case. This case, however, is by anyone's reckoning not a typical case because of the widespread emotional and economic trauma it caused. I do appreciate that he is also putting a bit more emphasis on the economic impact that it had to the town. I mean, I'm sure we'll hear more about that whenever he does testify in terms of like statistics and stuff. But I feel like of all the things, Dr. Edelman was just kind of repeated a lot of things. Again, he has great information, right? There's a lot of redundancy, but I do feel like, and it didn't really occur to me until seeing it here, I do feel like it was not really, he didn't really bring up the economic impact very much at all. I mean, he talked about how, so many of the citizens of Moscow are employed by the university, right? And a lot of them are employed by law enforcement, but he didn't talk about the economic impact to the, residents as a whole. So I do think I'm glad that he mentioned that. That is a good point. Because, it's not just the emotional damage, or emotional trauma, but the economic trauma. To allow jurors who have an emotional investment in the crime, an investment they may not even be conscious of, to serve on the jury would allow the prosecution to unconstitutionally start the proceedings with, quote, a thumb on death's side of the scale, end quote. I agree, 100% agree. And you know what? Look at the difference. Short but sweet, that was brief, it was straight and to the point. Well done, Mr. Sundby. A+. I guess I'm grading these now. No, I'm not. Okay, this will be the next expert here. Again, we will hear from this expert on August 29th. So rather than me butchering this name to smithereens, I'm just going to go with this individual's first name. I don't know if this is a male or a female. I'm going to go with this person's first name for now, and because I can pronounce this correctly, I think. Okay, so this is Dr. Amani. That's what we're going to call he or she. Social psychologist, social cognition researcher. Okay, so they have a report here. Assessment. This report is in regard to a potential change of venue for the Bryan Kohberger trial. Specifically, I was asked to report on the potential psychological effects of public/media attention towards the case on prospective jurors and determine whether a change of venue would reduce prejudicial bias against Mr. Kohberger. My report and final assessment were based on a review of the following. Peer-reviewed literature regarding relevant psychological phenomena, the Trial Innovations Telephone Survey. We read that. Results prepared by Dr. Bryan Edelman, assessing media exposure to the case across 4 counties. Dr. Edelman submitted declaration. Oh my God, there it is. There it is. No, my eyes. Sorry, I'm kidding. I'm half kidding. Regarding media impact on potential jurors, TrueScope's list of media reports regarding the case, specific online news stories that include content from authority figures. My recommendation based on this report supports a change of venue to a location outside of Latah County and especially outside of Moscow, Idaho, in order to increase the probability of a fair trial. The more far-removed jurors are from the case, the less bias there should be in their judgments about the defendant and the case, both initially and throughout the trial. It is clear that there has been extensive media coverage of the murders and the case against Mr. Kohberger within Latah County, as well as extensive social media activity involving informal discussions of the case. As I described throughout the report, empirical research has shown that when people are exposed to pretrial anti-defendant publicity, they are more likely to render guilty verdicts. Unfortunately, this bias exists even among those who report being unbiased, and it persists despite the receipt of trial arguments/evidence, admonitions to disregard the publicity, information, and jury deliberation. It is, another typo. Again, I just have to say, Scott Sunby, thank you for not having any there were no typos. It was very nice. It is also clear that the case has taken a substantial emotional toll on those in Latah County and continues to affect many members of this small, tightly knit community. Gee, is Moscow small? I thought it was a huge, big city. As discussed in this report, emotions can reduce impartiality. The elevated exposure to information and misinformation about the case, the lingering emotions, the closer connections to those involved, and the strong community cohesiveness would all be expected to contribute to potential bias among jurors recruited from Latah County based on what we know from empirical research about human nature. My background and qualifications. Okay, I'm not going to go over all this. Again, we will hear this from he or she when they testify. All right, my report. My report is based on my expertise in the field. As a social psychologist, I can identify a number of ways in which media exposure regarding the Bryan Kohberger case or the parties involved would likely bias the opinions held by the public and thus prospective jurors in ways that cannot be mitigated easily or at all. I describe them in this report. In doing so, I provide only explanations that are founded in peer-reviewed scientific research within psychology and related fields and provide endnotes to specify the references that were used. Excellent. Science-y sounding. There are 3 main sections to my report of the relevant research. I first review research on the effects of pretrial publicity on judgments of guilt. Afterwards, I discuss numerous underlying reasons for why such effects occur, with one section on how pretrial bias is formed and one on how bias persists during the trial. I then discuss research on efforts to mitigate potential juror bias. Where relevant, I also discuss some specific aspects of community involvement and emotionality, which could impact potential jurors if they were recruited from Latah County. And here's the report. 1. Pretrial publicity effects on judgments of guilt. According to the Trial Innovations survey results, jury-eligible residents in Latah County had high exposure to the case against Mr. Kohberger. Specifically, nearly all jury-eligible surveyed residents in the county were familiar with the case, and 68% specifically followed the case. 29% followed it very closely. There were also high percentages of residents who were familiar with specific facts and falsehoods presented in media regarding the case, and we are very familiar with all of this from Dr. Edelman. Okay, the studies included in the 2022 meta-analysis all involved experimentally manipulating exposure to pretrial publicity. In other words, participants were assigned, typically using random assignment, to be exposed to specific pretrial publicity or not, and then asked to review trial materials via summaries, transcripts, videotaped mock trials, or recordings of real trials. Random assignment to the different conditions of an experiment is used to attempt to create groups of participants that are similar in all dimensions that might affect their behavior. Although they cannot be used on real jurors, experimental manipulations, especially with random assignment, are particularly advantageous because they allow researchers to make stronger conclusions about cause and effect. In these designs, similar groups of participants are treated the exact same way and provided the exact same materials and instructions other than what is being manipulated, which in this case is exposure to pretrial publicity information. Thus, different guilt judgments between groups could be attributed to the pretrial publicity information. The 2022 meta-analysis found that anti-defendant pretrial publicity led to a significant increase in guilt judgments by individuals and guilty verdicts by groups, mock juries. Regarding individual judgments, most of the thousands of mock jurors exposed to negative pretrial publicity voted guilty, 55.4%, whereas fewer than half of the thousands who were not exposed to such publicity voted guilty, 45.1%. The anti-defendant pretrial publicity effect was over twice as strong when examining group verdicts. Among the 292 mock juries included in the analysis, about half, 49.7% of those exposed to anti-defendant pretrial publicity voted guilty, whereas only a quarter, 25.2%, of those not exposed voted guilty. Thus, there may be scenarios in which innocent people are convicted of a crime due to negative pretrial publicity. So they've separated these out by individual verdicts, like by essentially like surveying individuals, right, who participated as to their individual judgment. And then it looks like separately they were assessing these mock juries. So the verdicts were a group verdict, right, as like it would be on a jury. So, which, of course, in and of itself would be different because now you've had to have a unanimous verdict. So with the individuals, if they were exposed to the negative pretrial publicity, 55, I'll just round it, I'm going to round these, 55% voted guilty, whereas those who were not exposed to the negative pretrial publicity, it looks like 45% voted guilty. I would have expected a larger difference here. I would have expected, this is just my personal opinion, I would have expected for those who were exposed to the negative pretrial publicity, I guess if you're trying to use this as like, really makes a big impact, right? Like that's the whole point. I would have expected this number here to be higher, like above 60%, right? And also, I would have expected the number, like when you've got all these thousands of people and they were not exposed to it, I would have expected this number to be lower, like 40% or lower. And I just would have also expected them to be more than 10% different from each other. So I find that surprising. And then here, the second part, this is with the mock juries, right? So this, I guess, is more indicative of what I would expect, right? Where you've got a larger difference. So about 50%, if they were exposed to the negative pretrial publicity, they would vote guilty, and then about 25% would vote guilty if they weren't exposed. See, what this also shows you, it's interesting, what this also shows you, besides just the impact of the negative pretrial publicity, it shows the impact of people having to come together and talk about it with each other and reach a unanimous verdict, because like less than half would come to a guilty verdict versus when you're polling people as individuals, it was more than half, which is also interesting. Same thing with the ones that weren't exposed. That number is even a larger difference, right? It went from 45% when it was individuals to 25% when it was mock jury. Okay, the 2022 meta-analysis also found that pro-defendant pretrial publicity significantly biases participants towards not guilty verdicts. Interesting. I think it's really good that they included that, right? Again, speaking about bias, right? That's what this whole thing is about. This is showing that in performing this research, they aren't entirely biased because they tested it both ways, right? The 2022 meta-analysis also found that pro-defendant pretrial publicity significantly biases participants towards not guilty verdicts. Thus, bias can occur in either direction when prospective jurors are exposed to media reports regarding a criminal case. And of course, as we know, the only difference here is that the prosecution doesn't have a constitutional right, whereas the defendant does. So that's why there's more focus on publicity that's negative for the defendant. Oftentimes, why is that all one word? Yeah, typo, sorry, hate to say it. However, there is much more anti-defendant than pro-defendant media coverage, resulting in an overall prosecutorial slant. For example, in a study examining pretrial publicity for 20 capital cases, 75% of the media articles included some type of anti-defendant information. Arguably, even if the media presented equal amounts of pro-prosecution and pro-defense information, an anti-defendant bias might still emerge given that people have been shown to exhibit a negativity bias. That's true. Paying more attention to negative information about people than positive information, which is such a fucking shame, right? I hate that. But he or she is not wrong here. I mean, yeah. But I don't know. It's interesting when you think about, like, we know that that's the case, right? Like, clickbait, whatever. But when you think about the impact that makes when it comes to something like the right to a fair trial, boy, I don't know that I've really ever, like, sat and, like, really thought about those two connected in that manner. Like how, okay, human nature, right, and this negativity bias, and you could also say, is there a link potentially between humans and, like, our attention span over time, right? As technology, I mean, this is a whole other thing, right? But, like, there's so many examples of how our attention span has been changing over time, right? And then, things like instant gratification, and then you add in the negativity bias, and it's like, and then there's, like, a repetitive nature to a lot of this stuff too, whether it's advertising or whether it's social media. And it's really interesting to think about the impact that would have on a defendant's right to a fair trial. Based on their findings, the authors of the 2022 meta-analysis concluded that, quote, judges, attorneys, and policymakers should consider this pretrial publicity effect and the circumstances surrounding pretrial publicity when evaluating how best to protect criminal defendants' right to a fair trial when creating procedural safeguards. Although research studies have focused on the effects of media attention given to a case, this line of research can also speak to the influence of exposure to informal exposure and discussions as well, given that the underlying processes for emerging and lasting biases should still occur the same way. This is important given the Trial Innovation Survey results, which indicated that the vast majority of surveyed residents in Latah County participated in or observed discussions of the case in person or online. Well done on this, doctor, for including that detail. The rates for this type of exposure were substantially higher in Latah County than in other surveyed counties. This is not surprising given the pervasive fear in the community during the multiple-week search for a suspect. This social discussion was riddled with misinformation, as community members and family members searched desperately for answers, blah, blah. Okay, underlying mechanisms which contribute to bias. There are numerous potential reasons for why jurors might have a greater likelihood of reaching a guilty verdict after exposure to pretrial publicity and from hearing/having discussions about the case. There are a number of ways in which the media can shape impressions of a defendant or a criminal case. There are also cognitive and motivational reasons. Yeah, good job. Keep going. Woo! Anyway, that cause these impressions to be lasting, persisting during trial, even in the face of contradictory evidence. You can do it! No, wrong. A different type of motivational reason, I suppose. I discussed both categories of reasons below. Reasons for pretrial bias. As mentioned, exposure to more media can produce more prejudgment against, which can increase anti-defendant bias in a prospective juror. This can occur for many reasons. 1. Central and peripheral root processing. The elaboration likelihood model, I wonder if Fenderr has heard of this. Shout out to Fenderr, one of our Squirrel crew friends. A widely accepted and supported theory of persuasion suggests that sometimes people are persuaded via deep information processing. In parentheses, it says central/systemic root processing, close parentheses. And sometimes they are persuaded by factors extraneous to the persuasive message. Again, open parentheses, peripheral/heuristic root processing, close parentheses. Either route can persuade consumers of media stories to form a particular impression of Mr. Kohberger. A great deal of research in social cognition suggests that people rely on peripheral processing much more frequently. They take easy decision shortcuts due to so many reasons, including a lack of motivation to think hard about something, or an inability to do so, such as distractions, limited time, etc., or experiencing particular emotions that lead to more superficial information processing. Well, I will say that we kind of do things kind of the opposite here in Squirrel World, which is like, let's go down every rabbit hole and, like, overthink it and learn everything about it and, overachieve the fuck out of it, basically. Media stories may provide easy decision shortcuts that could cause people to make judgments of guilt regarding Mr. Kohberger. For example, one available decision shortcut could be that if others believe he is guilty, then he is probably guilty. Well, we literally heard that, and it drove me crazy. You guys remember how I lost my mind over and over again with, like, I think everyone's already decided he's guilty. It's like, what? Pardon you? Like, Oh my God. Just even thinking about it in hindsight, I'm already gonna lose my mind again. Okay. Attention-getting titles of news stories can also serve as peripheral cues that guide opinions without any deeper thought. Examples from the present case, taken from the True Scope listing of media stories, include the following titles. Kohberger indicted by grand jury. I'm not going to read all these. Let's keep going. People exposed solely to these titles could automatically form an impression of Mr. Kohberger. Okay, I do see what they're saying. The whole thing about the periphery. That's why. Okay, if I can paraphrase here. I think what the point here is that just by simply seeing a headline, and this would be true of anything in the news, right? Not just regarding Bryan Kohberger, but anytime you see a headline, right? How many times do you think there's people that just see the headline and don't read the news story, right? Even if it's just they're like at a grocery store and they're waiting in line and they see a headline on a newspaper, right? And then that's the piece of news. That's what this is about. And that, I'm sure, happens. God, I'm sure everybody, including me, is guilty of that. Like, we see this all the time with things that may or may not be true, right? Or it could just be that there's information missing or context missing where it would actually change the meaning. But anyway, the point being that just by seeing the title of a media story, right, and it gets the people's attention and it can guide their opinions without them having given it any deeper thought. People exposed solely to these titles could automatically form an impression of Mr. Kohberger as the killer without further thought or information if they are processing peripherally, which is what humans frequently do. They may not stop and think, for example, about how many people own knives and guns, and that the seized weapons may have no connection to the murders. Well, if they kept looking at headlines, they would eventually come to the one about the DNA on the knife sheath, but whatever. I get what she's saying. Or he. I don't know if it's a he or she. Authority influence. Media publicity of criminal cases can be especially impactful because a large proportion of the coverage includes information sources or who hold status or authority, for example, police or attorneys. Authority/status has been studied a great deal as a peripheral cue that people rely on automatically when making judgments. People are more likely to assume that information coming from those with the authority/status is accurate. Well, of course. Because people are generally raised to respect and believe those with authority/status, these types of sources can have particularly strong influence on people, and thus on prospective jurors' pretrial opinions. It makes sense that people would trust those with authority/status more, perhaps especially in a small, tight-knit community, you don't say, such as Moscow, Idaho, where they may know them personally. According to the Trial Innovations survey results, 22% of respondents in Latah County were, quote, employed or know someone employed by. I do like that whoever, I don't know if it's male or female, but I do like that this doctor references specific pieces of information that were gathered by this Trial Innovation survey. However, those with authority/status are subject to the same errors and biases as others, so unquestioned acceptance of the information from those sources could result in erroneous judgments. For example, some research finds that law enforcement officers may view evidence as more reliable if it is consistent with their preconceived notions about a suspect. Well, yeah, we certainly have seen that before, haven't we? If this influences which details law enforcement officers/agencies provide to the media or causes them to present details with more confidence than is warranted at the time, this could sway prospective jurors in the wrong direction. Research has also shown that information presented by the media may have a stronger prosecutorial slant when it includes commentary by law enforcement and prosecution. One study evaluating news stories about crime and criminal defendants found the source of anti-defendant content in news stories was most often law enforcement officers and prosecution. This, I think, right here, I'm going to read this again. One study evaluating news stories about crime and criminal defendants found the source of anti-defendant content in news stories was most often law enforcement officers and prosecution. Well, okay, my first thought was, you've got to imagine, this is why Dr. Edelman has made such a big deal about Bill Thompson coming out and making that press conference, encouraging people to read the probable cause affidavit. I wonder if these two have worked together before, because, anyway, it's just interesting, right? That it's almost like he was anticipating this to be the case. But also, I mean, I have to say, while ideally, like in a perfect world, a prosecution would just be going, they should want justice, right? It's justice, it's whatever that is, justice, whatever that means. We know that if they've arrested somebody and accused them and charged them with a crime, they have to believe that person did it, right? Like, in other words, yeah, it's essentially, it's like they have to believe that this person's guilty and this person did it, but literally everyone else, the general public, right, the jury, everybody else needs to be like, they didn't do it. But the prosecution I mean, it wouldn't make sense if they didn't believe that person did the thing, right? Because otherwise they shouldn't be charging them. So it's an interesting dichotomy there. But my point, I guess, is like they have to have an anti-defendant perspective, right? Like they wouldn't be doing their job otherwise. Moreover, the media may present commentary by those with authority/status as though it were factual information, even when it is more tentative or speculative. For example, a study examining 26 capital cases found that news articles primarily cited with those with authority and did so in a way that depicted law enforcement commentary as objective facts rather than details which might be disputed in court. Well, they will be disputed in court, for sure. This is another typo. I think this is supposed to say, another problem is that. I think these two words are swapped. It took me a second to try to figure out what they intended to say here. I believe these words are swapped, so I'm going to try to correct it for them and read it that way. Another problem is that indicators of authority/status, such as titles, uniforms, high-status occupations, can influence people on matters irrelevant to the authority's specific expertise. Moreover, those with authority/status have been shown to influence people to do things that make no sense or go against their own morals because they have faith in that authority figure who is directing them. Well, interrogations are a good example of that. If the Latah County community has been inundated with media regarding the Kohberger case, then they would have also been more exposed to information from those with authority/status and thus would have a greater probability of having developed preconceived notions about the case and about Mr. Kohberger based on that information. Regardless of the content of these impressions, the impressions could impact how these individuals might take in information about the case if they are to serve as jurors. There are a number of specific high authority/status sources which could have impacted impressions formed by consumers of media. One of these is Moscow, Idaho's chief of police at the time of the murders, James Fry, who is now running for sheriff. And as I noted, that was one of my 4 main takeaways of the things I thought were most noteworthy from the new to me information gleaned from Dr. Edelman's declaration, because I did not know that, and I do think that is a big deal. He made a number of statements to the press expressing confidence in Mr. Kohberger's guilt, despite a trial not have taken place. The weird wording. Good. The content and media stories that contained statements from prosecuting attorneys could also carry extra weight. Here we go with Bill Thompson. Weight due to perceptions of authority and status. For example, one news story reported that the prosecution intended to seek the death penalty due to their consideration of all the evidence known to the state about the case. In the same news story, the prosecution was also quoted as stating, quote, the defendant by his conduct, whether such conduct was before, during, or after the commission of the murder at hand, has exhibited a propensity to commit murder that will probably constitute a continuing threat to society, end quote. The prosecution has also been cited discussing information from the arrest affidavit, which was not filed under seal, and contained information which could influence opinions of prospective jurors. The thing is that the less factual information one has, really, like in any situation, but especially when it comes to crime, like especially murders, right? Like the less information the general public has, the more misinformation will be running rampant in its stead, right? Like people are going to just speculate and just run wild with it. Like they're going to go hog wild. But also, when you have factual information, you can use that, right, to stop and squash misinformation. There are some people that, let's say that they find out that they've been given incorrect information, that when they learn the correct information, right, the factual information, then they would rather be saying that, right? They're not trying to spread misinformation. Let's say that they just got it from somebody else. And then once they learn, oh, that wasn't correct, here's the actual thing, they would rather, they will actually, say that. And that's a good thing, because now what you've got is the transmission of facts to other people, right, versus misinformation. So all that being said, I just where I have trouble with these experts, all of them. Well, actually, not Dr. Sundby. Was he a doctor? Scott Sundby, Mr. Sundby, not him. But so far with this doctor and Dr. Edelman. Where I have trouble is in this thing of like trying to insinuate that by the prosecution, Bill Thompson, saying, here are some facts, here's the probable cause. Again, to quote Judge, these are court documents. He didn't just say shit, right? He said, read it for yourself. I mean, honestly, it's like you can't even have a more clear picture of somebody trying to stop misinformation, because he didn't, I don't even know that he read the probable cause affidavit, right? He said to everybody, go read it yourself. Here it is, go read it yourself. It strains credulity. That's what I want to say. It strains credulity for me to believe, or for me to accept, rather, that Dr. Edelman and this doctor, I forget his or her name, that I can't pronounce anyway, that the two of them would genuinely believe that the best option was to just not say anything at all. Don't you think that if that were the case, the misinformation would have been a bazillion times worse, and then they would have probably come out and said, like, I mean, there's 50,000 trillion percentage times more misinformation than we've ever seen in any trial ever. You know what I mean? Like, it would just be even worse. Like, it would only be worse. And that's the thing. Even in the survey, right, when they're like asking people these questions and they're asking them things that they could have learned from the PCA, look at those statements, right? Imagine if everything was under seal, okay? People were already complaining in the first place about the transparency and things, the gag order, things being under seal. Imagine if literally everything, I mean, thank God that wouldn't happen, because we're supposed to have transparency, and, dude, the way that would be problematic. But let's imagine a situation where, in this case, or any other case, but, here, everything was under seal, and we had no information at all. In your minds, can you even try to fathom the misinformation? Let's say we don't have anything. We don't even know who a suspect, like, literally, honestly, the country would have erupted into chaos. It would have, I can't even picture it. Like, a fair trial would be the least of your worries, really. So, like, you've got a situation here where the prosecution, there's a gag order, right? They're not just coming out and running their mouths, right? They're not just saying blah, 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 right? It's very limited information, but it's enough information to try to dissuade and deter and put an end to the misinformation and speculation and the rumors, and give people an actual document that they can reference themselves. And again, I really appreciate that instead of just saying it, he said, here, read the document yourself. It's it's available to the public, as it should be. Read it for yourself. I think that way it's empowering people to learn how to get accurate information on their own. He did it. Honestly, it's like, how could you do it? What would they suggest is the right way to do it? Do they have a better suggestion? That's really what it comes down to. Do they have a better suggestion of how this should have been handled? I would love to fucking hear it, because I cannot imagine for the life of me how it could have, how any prosecution team could have done more to limit misinformation and provide accurate information, but also without providing too much information, right? So this is why I have trouble with it, because I can't see how a reasonable person can say these statements, right? It makes me doubt. It does for me. It does, honestly. It does for me call into question their credibility. It really does, because it's not reasonable. It's really not. When you look at it, it's really not reasonable, because there is no other option. Any other option would have only provided a situation where the pretrial negative publicity and prejudice would have been exponentially worse. It's just not even a question. You would have had to go to Mars to get a fair trial. So, maybe not even then. Again, and contained information which could influence opinions of prospective jurors. What would you have him do? Let people come up with every type of rumor? It's just not. An unquestioned reader of these media stories could trust these implications of the defendant's guilt and the evidence against him. Scott Green, the president of the University of Idaho, is another person of authority/status who may have perhaps inadvertently influenced opinions of prospective jurors. After Mr. Kohberger's arrest, he sent out a campus-wide Now, there are people who maybe didn't handle things as best they could, and I think that's very different. And so, yeah, anyway, that's all I'll say. Who may have perhaps inadvertently influenced opinions of prospective jurors. After Mr. Kohberger's arrest, he sent out a campus-wide communication expressing relief and implying that the case had been solved. This communication was also reproduced within a chapter about the Moscow... Right, and he wrote the fucking book. Like, why the fuck, then, are we spending so much time and energy addressing Mr. Thompson when this fuckery has been going on? Like, honestly, it's like, does he want to be the next Becky Hill? Like, what is happening? All right, classical conditioning effects. A third reason for preconceived notions developing about the defendant is classical conditioning. I think that's like Pavlov, which occurs when people develop reactions to previously neutral stimuli. Yeah, the Pavlov, right? Because of what those stimuli have been paired or associated with. In the present case, Bryan Kohberger's name or image could evolve from a neutral stimulus to a negative, quote, conditioned stimulus, end quote, if presented with anything that may evoke a negative judgment or reaction in people. Simply pairing Bryan Kohberger's name or photograph with... So what if you pair his name with, like, a cupcake every time? Then are people... How is that going to affect people? Bryan Kohberger's name or photograph with negative terms like murderer or killer, or with aversive details regarding the murders that took place, could cause people to develop a negative reaction to his name or image, even if they did not believe him to be the killer. I mean, yeah, I'm sure that's true. Classical conditioning theory was... Are you going to mention Pavlov and his dog? Classical conditioning theory was developed over 100 years ago, and there are many decades of research supporting the theory. The relevant studies that have shown neutral stimuli, for example, words, pictures, etc., that have no initial effect on us, can evoke certain emotional or evaluative reactions if they have been presented with stimuli that naturally evoke some response. This conditioning occurs very quickly and automatically. In such studies, participants view/hear neutral words or images paired with something that may trigger a reaction, like negative words or images. Later in the study, often just minutes later, participants' judgments of those words or images are no longer neutral. I'm surprised that we're not getting, like, actual data or statistics here. This seems kind of vague. For example, in one such study, every time participants were presented with a particular man's name, they heard a negative or positive word. Example, failure or gift. I'm going to push down here. I'm only saying this because this is in line with this exact topic, right? This entire thing here is essentially, there's a premise here of a neutral stimuli, right? And then you have a negative stimuli. Now, that premise only works if indeed the quote-unquote negative stimulus word that's going to be used if they already know that that word is perceived to be negative by the person, right? So they're talking about negative words versus positive words, right? They did not establish here that for everyone who participated in this study, the word failure had a negative connotation, or that the word gift had a positive connotation. And here's why I'm saying that. Because for some people, the word gift could have a negative connotation. It's entirely possible. So you need to first establish, you can't just say these words and assume that everybody's going to have the same association with them. Literally, that's what this entire paragraph and topic here is proving, right? That people have these different associations with words or images, what have you. And so by that same logic, then, you can't just blanket say, oh, the word gift is always positive to people. So this entire premise only works if you've first established that correlation. Okay. So every time participants were presented with a particular man's name, they heard a negative or a positive word. Example, failure or gift. Do you see why I'm saying that this could be a problem? If the entire study is based on this, but they didn't bother to, assess the correlations that people have with these words beforehand. Anyway, after a few dozen 5-second trials, participants rated the name that had been paired with negative words less favorably than the names that had been paired with positive words. Again, that only works if you've established what words are positive and what words are negative to the individuals in the study. This can apply in cases where Kohberger is presented with words such as killer or murderer, even if those terms are not used as specific descriptors of him. Some news and social media stories about Mr. Kohberger have compared him with a well-known murderer, a pairing which could certainly reduce perceived favorability of Mr. Kohberger. Classical conditioning effects even occur when exposure to word pairings is unconscious. In one study, Pictures of a stranger were presented consciously, but alongside subliminal presentations of positive or negative images that had nothing to do with the stranger. Participants who were presented with the negative subliminal images developed more negative evaluations of the stranger, including different judgments about the stranger's personality traits than those who were presented with positive subliminal images, despite the photographs being flashed too quickly to be perceived at a conscious level. I want to know what the images were. And again, like I said before, all of this, in my opinion, is completely moot if they didn't somehow initially assess, for the individuals who were participating in this experiment, if they didn't initially assess that they perceived an image as positive or negative. Thus, it seems clear that people who have been exposed to negative media coverage of Bryan Kohberger, perhaps even briefly while scrolling through a social media feed, could have an automatic negative reaction to his name or appearance and perhaps not even know why. I just find that kind of unlikely. I'm pretty sure people will associate him with 4 people dying. And I mean, whether they should or shouldn't, it isn't even the point. I'm just saying that's going to be, that's why they're going to have a negative association, I would suggest. Even if the coverage does not portray Mr. Kohberger negatively or present him as guilty, right, which that's what I'm saying, is it doesn't have to, right? But his name and face are presented alongside aversive information, right? He's associated with these people dying. That's true for anybody, even if they're acquitted of a case, right? Details, images, thoughts, or words involving murder, the pairing of Kohberger with negative stimuli could still result in the same negative conditioning. People exposed to more media about the case would naturally be exposed to more of these pairing, that should be plural pairings, and likely have a stronger conditioned response to Mr. Kohberger's name and image. Emotional/motivational influences. Another reason why jurors recruited from Latah County may struggle to remain unbiased is that emotions ran high after the murders took place in the... I swear to God. I should have been counting. I'm going to do a Control F myself at the end of this for all the words that I have made fun of for being repeated over and over again. And we're going to do that at the end of the video and see what we got. Actually, what we could do is you guys could kind of guess if you wanted to and put it in the comments. And then on the next live stream, we could reveal the results and see who got closest. That might be fun to do. Okay, anyway. Right. Small, tightly knit community of Moscow, Idaho. This led to a lot of sharing and communication and likely spread of emotions. Spread of emotions? Like they're contagious? Throughout social media and other discussions about the incident, evidence of emotional impact on Latah County residents can be gleaned from the Trial Innovation Survey results and Dr. Edelman's submitted declaration report. These indicated that University of Idaho students were so distraught that they felt they could not begin healing until the house where the murders took place was demolished, which ultimately it was by the university. Okay, so this is not correct, you guys. This is not correct. In his declaration report, okay, there was at no point did his team, Trial Innovation Surveys, at no point did they survey the University of Idaho students, for the whole campus, and ask how they felt about the house. That never happened. What happened was that they simply used the headlines, right, as examples of people feeling negative. But, I can go ahead and quote this expert back to herself, right? I believe it was the same expert talking about the peripheral, whatever the fuck it was, peripheral shit. And I was talking about the example of headlines, right? Where it's just a one headline thing and then people assume it's true. Perfect example. Because everything that he presented about people feeling negatively about the house was just simply headlines, okay? And from myself following this case since it first started, I said the same thing, which was that I have had yet, and now I could be wrong, okay, but I didn't see, and I don't know of anyone that actually saw any interview, whether it was a video or a written statement or anything from students where the students themselves said they felt negatively about the house. All I saw was just headlines from, mainstream media or whatever, or from the president of the university, right? Scott Green. Basically people making assumptions. That is all I saw was people making assumptions about how people felt, about how the students felt about the house. I never saw anything where it directly quoted a student or interviewed a student, anything like that. So what's interesting here is that this is completely incorrect. Evidence of emotional impact on Latah County residents can be gleaned from the Trial Innovation Survey results. These indicated that University of Idaho students were so distraught that they felt they could not begin healing until the house where the murders took place was demolished. This is all false. and he was literally he was only including it really to show headlines of people being emotional or whatever, but it was just the freaking headlines of the different media articles or whatever. It wasn't, again, and it's funny when you think about it, it's funny that would even be included, because there are a lot of pages that were like that. I actually scrolled through them. I was like, yep, we've all seen this, but it's funny that he would even include that, because this expert has indicated how problematic those are. It's kind of getting to be a mess in some ways with this, okay? They definitely cross-checked between the experts with, like, blaming the prosecutor, right? And also calling the community small, tight-knit. They cross-checked that with each other, but I don't know that they fully talked about some of these other details, because I'm finding contradictions here, okay? Anyway, but this is just flat out incorrect, and clearly this expert did not actually, like, really read what that portion. Now, this expert has utilized other parts of his declaration really well, and I already have pointed that out several times, but I don't think they read the part where it talks about the House, because this is actually not correct. All right, which it ultimately was by the order of, here we go, keep reading, the University of Idaho president. Even in the face of objections from the victim's family members, the emotional impact is also evidenced in, okay. So again, I don't think you can use this House situation. I don't think it's fair to use the House and what happened to the House as any indicator one way or another as to the way the community or the students feel, because it was a decision that was made by the president of the university. And we all know, if anyone's got ulterior motives for shit, let's look at the guy who wrote a book, okay? The emotional impact is also evidenced in the numerous, and the candlelight vigils again, the candlelight vigils. Oh man, I need to add that to the list for once to do a word count for. Let me write it down. Candlelight vigils held for the victims and their families, and the creation of a healing garden. The healing garden, that was the other one, right? Along with sadness, there was also widespread fear during the long search for a suspect. As seen in the Trial Innovation Survey responses from Latah County, people felt a sudden sense of disruption in what they perceived to be a once innocent, peaceful, and safe community. Survey respondents noted being afraid to go out alone, running from their cars to buildings, locking doors for the first time, increasing their personal or home security, etc. Fear among University of Idaho students and how some did not return to campus was also mentioned. Some respondents indicated that they still feel emotional to this day. This is logical considering that community members were for a long time advised to remain vigilant. Okay, again, and here's with the stress, anxiety, or fear. Any law enforcement anywhere, their advice to people anywhere is going to say always remain vigilant. So I just, I said that before, just saying it again. Okay, I'm gonna go on here. Reasons for ongoing bias during trial. Once a person develops impressions about a defendant's guilt, those impressions can impede the individual's ability to be a fair juror. As mentioned previously, more participants in Latah County recognized, okay, this is really, honestly, some of this is, it's a lot like with Dr. Edelman, it had this expert had a lot of really good points, and it feel like it's losing them as it goes along. Like, it could have just stuck to the first couple pages where there were some really good points. I think also another flaw is, like, they're not backing up some of the shit with their those experiments that they were talking about. Now, maybe that will be fleshed out more in the hearing, but I would rather have seen extra pages detailing how they went to determine if something was negative or positive in the first place to somebody, and verifying that, right, as the basis for the study or the experiment, rather than repeating, literally just rephrasing what Dr. Edelman rephrased in his own declaration about 5,000 bazillion times. So yeah, so confirmation bias, I mean, again, it's interesting that they're not giving, like, extra psychological insight, but instead just quoting the results of the studies that Dr. Edelman did. So it's not, I don't know. Again, it's just not really that great. Belief perseverance resulting in more predecisional distortion of information. Okay, this is new information. So if potential jurors have more than just a mild suspicion or expectation, and have formed a clear initial opinion about Mr. Kohberger, their perceptual biases can become even stronger. Belief perseverance, got a new term, guys, is a phenomenon illustrating that people's beliefs often persist even when presented with information that completely discredits those beliefs. Great example, flat earthers. Bam. Great example. Paul O'Keefe. The more confident people are in their initial prejudgments, the more pre-decisional distortion will result when interpreting subsequent information. Media consumers may become more confident if they are exposed to more media coverage about a case, and that if the media coverage presents stronger suggestions of a defendant's guilt, confidence of Mr. Kohberger's guilt may have also arisen from the motivation to feel safe within the community. That is not anybody's fault, though. That is a human coping mechanism that you can't, that's understandable, honestly. All right, cognitive dissonance effects. I think cognitive dissonance is really fascinating, so let's see what they have to say about this. Another potential obstacle for impartiality among prospective jurors recruited from Latah County is their connection to their community. Wait, is this a small, tightly knit community, or is this like a large, bustling metropolis? The small community came together after the murders, holding fucking hell with the vigils again. I can't. Okay, all right, I'm sorry, skipping that paragraph. Can't do it. According to the well-established theory of cognitive dissonance and the many decades of research supporting the theory, people often distort reality in order to avoid feeling an inner sense of hypocrisy or conflict. Because of this, I think it is highly probable that a juror from Latah County would be more likely to unintentionally favor information that supports a conviction than would a juror from another area. Yeah, I mean, this makes sense. Reasonable. A 2017 mock jury study showed that in mixed juries, the biases among those exposed to pretrial publicity can spread to other jurors during deliberation, like the plague. Subsequent experimental research in 2021 yielded the same result, showing that if some jurors are exposed to pretrial publicity information, that information can steer the discussion in the same direction. For example, anti-defendant. I love they only give the one example. And there's only going to be two options, right? Anti-defendant or pro-defendant. When you're talking about emotions amongst jurors that might spread like the plague. During jury deliberation with jurors who had not been exposed to the plague, ultimately affecting post-deliberation guilt judgments. Thus, deliberation is not seen as a method for eliminating pretrial publicity exposure effects and can even worsen them. Well, it's not. Who would ever think that it's... Dude, nobody's saying that the point of deliberation is to eliminate pretrial publicity exposure. Anyway, and can even worsen them because it provides a means to spread information to jurors who had not yet been exposed, like the plague. Moreover, group discussion tends to cause a group's... Why is it helter-skelter? Anyway, moreover, group discussion tends to cause a group's initial leanings to become stronger or more polarized after group discussion, a widely researched phenomenon known as group polarization. All right, conclusions. My conclusion from the review of the research is that pretrial publicity effects on judgments tend to affect judgments of guilt and are pervasive, lasting through the trial, and hard to reduce. As such, the best way to prevent them, based on our current knowledge base, would be to utilize jurors who have not been exposed to such coverage. Moreover, the probability of a fair trial should be greater if jurors are less emotional. I'm getting fed up with the typos, you guys. I have to go. I'm sorry. I have to goat. I have to goat. Deep breaths. If jurors are less emotional invested, it's not that hard, people. Just proofread or get someone else to proofread. I can do it. You guys, I'll volunteer myself to proofread because this is so frustrating and it's very distracting and I don't want to run out my goat's battery either. One more for the road. Let's hope that's the last time the goat is needed today. Okay, so I just, and it's like it's at the very beginning of a paragraph. Less emotional invested. I'm almost sick of correcting it for everybody, right? But it should say emotionally invested. In connected with the case, for the reasons noted in this report, research suggests that preventing/limiting emotions among jurors in the first place is a more effective path to objectivity than trying to reduce the effects of emotions on legal decisions. Because of the difficulties with asking jurors about their exposure and biases, it would be best to recruit jurors from a location in which there has been less media exposure. Well, there you have it. To information, less discussion regarding the case, and less personal and emotional investment in the case. Although this case has received widespread national attention, residents within Latah County appear to have had more exposure to the case and been more personally and emotionally invested in it. Like I said, just go to Mars. You might be able to find a jury there. Thus, my recommendation for a change of venue to a location outside of Latah County. You're joking me. Sorry, I take it back with the goat. You guys, this is the last sentence. Did you notice how I read that? I read it as if it wasn't the end of the sentence. I'm going to read it again the way I just read it, okay, which was before proofreading it and correcting it for them. Here's what the sentence says. Thus, my recommendation for a change of venue to a location outside of Latah County would be fill in the blank. But no, the sentence ends there. I'm going to lose my mind. This is the last sentence of their entire thing. They left out the words, it is. This is missing a verb. It's missing. Okay. All right, we're done with you. We're done with you. I think there's one more person. Hang on, guys. This is their... I don't even give a shit, honestly, dude. They can't... I'm done with this. I'm done with these people. Done with them! Now, this is the last one. I'm going to butcher this name again, so we're going to go with... Yes, okay. We're going to go with Dr. Veronica. Okay. So, Dr. Veronica is the Director of Survey Operations for the Nevada Center for Surveys, Evaluation, and Statistics. She's the director of the Grant Sawyer Center for Justice Studies at the University of Nevada at Reno. She received her Ph.D. also from University of Nevada at Reno in interdisciplinary social psychology. She has over 20 years of experience. All right, moving on. History of survey research. Shout out to history again. Survey research has a rich history that dates back centuries, evolving significantly over time to become a cornerstone of social science and market research. Early forms of surveys can be traced back to ancient times, when Romans conducted census polls to gather data on population and properly tax for administrative purposes. Cool! In the 17th and 18th centuries, modern surveys appeared, with the development of probability theory, which laid the groundwork for more scientific approaches to data collection. In fact, the concept of sampling, as opposed to a complete enumeration process, began to take shape during this period. In the 19th century, more systematic data collection methods emerged. The U.S. Census, which was introduced in 1790. You guys, I love this person because we're learning. We're learning. The U.S. Census was introduced in 1790. Holy shit. Became more sophisticated, and social surveys, such as the study of poverty in London by Charles Booth, provided detailed societal insights never before measured. From the late 20th century to the present, technological advances, challenges, and innovations emerged. The invention of computers and the internet revolutionized survey research. Online surveys and sophisticated data analysis software have made surveys more accessible. Simultaneously, contemporary research also brought numerous challenges. Why is it lopsided again? Cattywampus. Simultaneously, contemporary research also brought numerous challenges such as declining response rates and issues of representativeness, but innovations in data collection methods such as mobile surveys and mixed mode approaches and statistical techniques to combat response rates and representativeness. That sentence, let me try that one again. Is that me or is it her? I really hope it's not her. I really want to have 2 out of 4 that can, type up a thing. That's the fancy term. It's the official term. Thing. A declaration or what have you without it being riddled with errors. Let me try this again. Is it me or is it you? Simultaneously, contemporary research also brought numerous challenges, such as declining response rates and issues of representativeness, but innovations in data collection methods, such as mobile surveys and mixed mode approaches, and statistical techniques to combat response rates and representativeness continue to evolve. Well, it's not in quotes, so I don't know that this is a direct quote from this book. I'm going to give her, I think it's okay. I think it's just kind of an awkward sentence, but I don't know that that was of her creation. All right. Surveys used in numerous fields. Survey research is a versatile and widely used method across numerous fields of study to inform decision-making and advance knowledge. Survey data collection allows researchers to gather data on opinions, behaviors, characteristics, and other variables from diverse populations in numerous fields, such as in the social sciences, market research, health and medicine, law and justice, education, economics, environmental studies, political science, public policy, and technology and innovation, to name a few. Some examples, okay, we don't need to read all this. We know what surveys do. Sorry if there's any noise. That is the people next door mowing the lawn. Okay, community attitude surveys. None of this is really all that important. Survey research and change of venue studies. Here we go. Change of venue studies utilize survey research to assess potential biases within a community to inform legal decisions to ensure the fairness of a trial. These studies are conducted to determine whether a trial should be moved to a different location to ensure impartiality. For example, there are 3 objectives of change of venue studies. 1, assessing pretrial publicity. 2, evaluating community bias. And 3, assessing juror impartiality. Assessing pretrial publicity involves determining the extent and nature of pretrial publicity and its potential impact on jurors' impartiality. Evaluating community bias involves measuring community attitudes and biases towards the defendant, the crime, or the circumstances surrounding the case. Juror impartiality involves assessing the likelihood of seating an impartial jury in the current venue. While I could discuss the validity and reliability of survey research generally, which involves numerous topics such as content validity, construct validity, criterion validity, internal consistency, retest reliability, and inter-rater reliability. I've been asked to speak specifically to the validity and reliability in community attitude surveys and the modality of telephone surveys. Okay, so I'm sure we're going to hear her elaborate on this at the hearing, because it's going to, I think the goal is going to be for her to, speaking of validity, right, to show the validity of the telephone survey that Dr. Edelman's team did, which we did. I don't know if you guys remember Roberta. Shout out to Roberta. Yeah, that was the telephone survey. Just to make, because hopefully that will refresh y'all's memory. That's what that was. That was the telephone survey. Okay, so kind of more of the same. We can go forward. And references. Is that it? Are we done? 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 Her curriculum vitae. You guys. Wait, no, there's more pages. What are the other pages? Is this just really fucking long? It might be really fucking long. Hold on. We have 17 more pages. Is it just going to be more of this, please? This was long. That's what she said. Wow, she's very prolific here. Yeah, this is all her shit. This is her shit. Yup. This is her shit. You guys? Oh my god, 2 more pages. Are we done? Are we done? Are we done? One more page. That's it. We did it, guys. We did it. Round of applause number 2. Oh, wait. Sorry, y'all. We have one more document, but it's really short. Hold on. We're almost done. Let's just get to this last document real quick. Here it is. See? Short but sweet. It's the order sealing the exhibits. So remember, because we covered the motion to have them sealed or whatever until the hearing, you guys, we're almost done. All right. This was a fucking deep dive, wasn't it? John Judge, the court having before it the stipulated motion to seal exhibits and good cause appearing now, therefore, it is hereby ordered that the portions of the exhibits to the memorandum in support of motion to change venue contained on the USB flash drive. So as far as the USB flash drive, if you guys remember from like 1,000 years ago when we were at the very beginning of this journey, they mentioned the USB flash drive. Remember, it's things like PowerPoints, other PDF shit, stuff that they didn't include in the memo. Yeah. That's what they were. I.C.A.R 32, as always. You know, you can't always count on things in life, right? Let me rephrase that. There's few things you can always count on in life. One of them is that in, I would say, every document without fail, since I started covering this, that in every document, you will see I.C.A.R 32. Y'all, keep me honest. If ever I cover a document and you're like, oh my god, there was no I.C.A.R 32, let me know if I don't notice it, and I will eat my words. But as of right now, you guys, if any of you out there are watching and you're like, wow, I really just feel like I need something I can rely upon in life, this is the thing. This is your thing. I.C.A.R 32. All right. Okay. Oh, I'm going to do the Control F myself. Right. I said I would do that. Here's what I'm going to do, guys. Here's what I'm going to do. I'm going to do the thing where you have you guys guess. So here's the words, the keywords, okay? So the 3 words, these are the words. I'm going to do the Control F, not right now on screen. What we're going to do is I'm going to do the Control F. We'll do it at the live stream, actually. I'll do it live, and that way everyone will be surprised, including me. I won't even know the answers. So you guys can make guesses if you want. You can do that in the comments, or you can do it, you know, when we talk about it live. But here's the words, okay? Here's the 3 words that we're going to do for this game. Attitude. I remember having an attitude about how many times that word was used. Candlelight. And anytime that appears, that's going to be in reference to the candlelight vigil, because that was another one. I was like, oh my god, I'm so sick of this candlelight vigil. So candlelight is number 2. And then the 3rd word is prejudicial. Because another one of the things that was really annoying me was all the P's in a row, but we're not going to do all the P's. We're going to do just prejudicial. So attitude, candlelight, prejudicial. Those are the 3. So, yeah, so that's that. So, y'all, if you aren't already subscribed, make sure you subscribe. And if you are interested in joining the Discord, I post links for that usually during live streams, but that's a great place to continue discussion, hang out with the Squirrel crew, and it's a no-fail way to get notifications. As we all know, on YouTube, they don't always go through. So, It's also a place where we can share documents, videos, links, all kinds of stuff. It's awesome. It's really great. We love our Discord. So, and the other thing is that we're going to start doing a movie night. And I'm working on getting that set up, but that's another thing that will happen through the Discord. But yeah, other than that, I have playlists for all the different coverage I've done of trials. There's also music playlists for anyone who likes music, because initially, I'm, all of my videos were music related until I started covering trials as well. So I have music playlists, guitar, violin, etc. as well. Right now, we're still keeping an eye on Karen Reed, but we took a little break from just the intensity of that to have some fun with revisiting Duffy Heard. And then we are also going to be starting the mystery trial, I believe tomorrow, after the first live stream, it will no longer be a mystery. But I'm really excited about that. So yeah, so that's all that's going on now. And thanks you guys for watching. Thanks so much for being a squirrel. Oh, and also, lastly here, if you are interested in joining the Squirrels of the World project, that is taking place through the Discord as well. So that was the other last thing. As I thank you guys for being a squirrel and for being a Squirrel of the World, for anyone who wants to join, that the Discord is where it's at. All right, that's it, and I'll see you guys on the next video.